All right. All right. Hello. Hello. This is me talking to people who might be watching this in the future. Hello. Welcome to Legal Investigations. We're going to be. This is where I talk about live seminar. Talk about not live seminar. We're talking about legal stuff. All right. Gonna educate you on things that it's important to you. Hi YouTube. Yes, hi YouTube. Man, my nose is itchy. So every time I do legal investigations, we're going to get a deep dive into whatever subject we're looking and talk about it here and there everywhere. But for today, it's going to be tenancy agreements. Basically, if you're a tenant or if you're a landlord, this would be very relevant to you. Or if you have any friends or family that is, how do you say, are in this sort of situation. I think most people are. That's why I would say this is like a very important life seminar for people to look at. So because there's so many things we can talk about, and most likely everyone has a thing they want to ask or discuss about or have issues with. So yeah, hopefully there's a lot of engagement for today's live investigations. So yeah, so let's see. What's the first thing we want to talk about? Okay. What is tenancies? I would say that is the perfect question to everything, right? To open out a big can of worm. What is tenancies? I would say a person. Very simple. A person who it involves two people, right? Sorry, involves two parties. Man, why is it with this weird landlord who is the legal owner of a property, then tenant who is the person occupying a property owned by the landlord. Right? Very simple, right? Very simple. Okay. What's agreed in a tenancy? Very simple as well. Man, am I taking this too slowly? But well, yeah, we're trying to build a mental picture right now, so let's say this is pretty important to lay it out as first, so people get an idea. Okay, what's agreed in a tenancy? Landlord, right, agrees to rent out a property to the tenant in exchange for rent. It could be monthly rent. It could be, well, this could be weekly. Most of the time it's weekly or monthly, depending on how long the contract term is. Monthly rent. Paid on a weekly or monthly basis. Both parties, so tenant would all rent out. How do I say this? Tenant would have the legal right to occupy this property for whatever time period that both parties have agreed on, right? So simple as that. But of course, you know, there's so many things about it, so many different things that a tenancy that both parties can agree on. It's very small specific details which we'll look into one by one. But for most people, I think the question is, why does both parties need a tenancy agreement? Right? Yeah, you know, I have to like clarify this though. Sometimes people use the word tenancy. Sometimes people use the word lease. So I'm going to clarify this, all right? Tenancy does not equal to lease. Simply because of the difference in time. I'm going to just in time, or it could be what each countries define them, right? For Malaysia though, right? For Malaysia, lease tenancies are for properties for properties that are being rent on for maybe for like less than 3 years, something like that, if I recall correctly. I have to confirm this. Three or 5 years. Yeah, so correct. Tenancies are properties that are being rented for less than 3 years, and leases are for properties that are being rented for more than 3 years. Okay. There are different legal implications for this, right? Suffice to say, tenants, right? You can say it. You could refer to these people that are in leases, lessees. I think that's how you word it. Of leases have better rights than normal tenants. Not, I wouldn't say normal. Regular tenants, something like that, right? It's not really that a big of a deal. Whether you are like renting a place for promise to rent a place for more than 3 years or less than 3 years. When we are thinking about all the smaller details of renting a place, but simply put, right, at least in Malaysia, anyone that rents a property that's more than 3 years, they have better rights. Meaning to say they're kind of like legal owners themselves, in the sense that they, in regards to registration or recognition, legally recognized as a person occupying the property, you have better rights in being recognized. You have better rights in registering your lease with the relevant government authority. For Malaysia, it's land officers. They call it land officers, and that's where, if let's say your lease is more than 5 years, more than 3 years, or whatever, it's where you can register your lease. You can take your documents, all relevant documents, and go to a land office and register it. Why do you want to register it? It's basically to solidify your rights over the property, over anyone else's. So if let's say, if we are talking about occupation rights, you would have the better right. You have the better things. You would be better recognized. You have more solid evidence to say that you are the person that the landlord is renting out to us, and you can't simply evict evict you as someone who is renting for a place for a very, very long time, right? It will take more procedures to do so, but the procedure is a bit complicated. I won't really go into it because not a lot of people want to, in practice, right? Not a lot of people want to rent a place or promise to rent a place for such a long year, for many years, because people want to have the flexibility to move to a different place whenever they can. So that's why most of the time you see that when you see tenants, people renting places, it's for maybe 1 year or 2 years or 3 years max. And at most, if they want to stay longer, there will be negotiations for renewal of the tenancies, right? You don't have to promise to stay at a place for many years. You can always put in on a case by case, on a yearly basis, in the sense that once the 1 year tenancy period has ended, then both parties can reconsider. Okay, do we want to renew it again, or is it necessary to talk about it again? Unless you want to give sufficient notice that you don't want to continue with the tenancy anymore. You don't want to continue renting the place anymore for either party, right? That's something that is very important for anyone that's renting a property to look out for, right? Which I think recently we talked about this in one of my favorite VTubers, Raika. She just rented a new place, and I hope it's sounds like everything is going very well. But last time, the current one, at least she is still in. It's not, the landlord wasn't really how do you say, courtesy, doesn't have a courtesy to inform her that they don't want to rent the property again, rent the property for next year. And yeah, that's as a problem can be resolved if, or at least be cautious of when we are aware of how agreements are made, what the terms and conditions we need to look at when we like renting a place. There's so many things. Of course, some people don't. I would say some people. There's a lot of people who aren't really concerned with terms and conditions, as long as they can live there easily. They can get things done easily and just straight moving to the place. I understand all this, right? People don't want to be too bogged down with, or this must be in this term, this must be in, this must be talked about, this has to be confirmed in writing before everything is moved. A lot of times, it's been when people like are looking for places to live places to stay. It's on a emergency basis, or it's on a short notice. We don't have the luxury of time to think or like look into contractual terms, and then this only afterwards decide whether they want to live in the place. Most of the time, we're only looking at what's the monthly rent, how's the place, does it look good, where is the place situated, what does it have, and that's pretty much it. We don't really concern ourselves with anything else that is living there, that legally speaking is very risky to not consider at all, but we'll look into all that in just a bit. All right, but yeah, I hope am I being called out? Well, not you specifically, Isaac. I even know lawyers, all right? I even know lawyers who are renting places, don't sign any contract at all. Maybe they only dealt with a agent, right? A sales agent in trying to get people to rent a place, and that's pretty much it. Most likely, they're just gonna sign a booking form or something like that, and they will be provided an agreement. Maybe you didn't know, you signed an agreement, you don't know. A booking form technically is an agreement, although it's very brief. It doesn't contain a lot of terms and conditions. But if that's the only document that you have signed to rent a place, that is considered the main contract. Everything else, that was done before would not really be anything. Like, say, the agent promising you anything through conversations and such. Most of the time, once you sign a booking form, there should be an agreement that you sign afterwards, which is standard, provided by the sales agent as well. It's not done by the landlord, it's not done by tenant at all. Normally, these things are done by the agency themselves, which a lot of times, the agreement, the terms and conditions of this contracts is very biased. At least biased against the tenant. It always favors the landlord if you don't change the terms and conditions. So yeah, that's something even lawyers don't think about, because life is, as always, I always understand, or at least try to think of reasons why people don't look at contracts, is because there's so many things to think about, to worry about, to frustrate about. If anything, you don't want to look at any more. If you can not look at things, look at especially terms and conditions, you would choose not to, right? For the sake of ignorance is bliss, right? Ignorance is bliss, quite literally. And I can't blame people for it, because I myself have been in situations like that. I have ignored things, and regardless of whether there's serious consequences to it, but then of course, once the consequence comes, you will regret it. So then again, that's why I've been very cautious with doing things as a content creator, right? Even though things have not happened to me, and even though that things seem like won't be likely to happen to me, it doesn't matter, right? For me, it's like wearing a seat belt. Like a lot of times, yeah, wearing a seat belt, being cautious when you're going out, keeping your belongings safe when you're going on vacations, all that stuff. Even if it's not likely to happen, you still have to be careful, right? We cross that bridge later. Yeah, you say that, Isaac, but I've there's so many. When you work in this field, right? I am a lawyer that is specialized in conveyancing, so I've dealt with a lot of situations involving properties, which includes renting problems. People who are renting or people who are renting out properties have all kinds of different kinds of problems, which at the end is always because either they don't have any agreement or they don't look at what their terms and conditions in the agreement they have. And just what happens, they encounter bad tenants or bad landlords. And when they seek advice, it's most of the time it's like, we're trying to salvage the situation, because you can't really go against terms and conditions when you have signed the agreement. When you have agreed to all the terms and conditions, you can't be like, oh no, this thing has happened to me, I don't like it, I'm going to find a lawyer and try to sue the other person or anything. When you try to do that, it's the situation is not going to favor you much. The only thing that we can try to do is try to compromise the situation to see a way that doesn't further cause any more damage against you, any losses against you. Right? That's the thing why I don't like to, be a lawyer, because I'm not helping people that is supposed to get help. I'm in the sense that these things could have been prevented if people had just be a bit careful, right, when making all these very important life decisions that I'm making, right? This, which affects a lot of people, right? If let's say you're renting, if you have a family and you're renting a place for a family to live in, right? It's very important to consider all things that might affect your family's living situation, right? What happens if the landlord doesn't continue to rent it out to you, or what happens if the landlords harass you or something, does something can be considered illegal but isn't really illegal, or tries to strong arm you in like increasing the rental payment, monthly rental payment, or all sorts of things, right? That's with a landlord that might happen to you as a tenant, or vice versa, right? As a tenant, you might be facing, as a landlord, you might be facing problematic tenants that might be doing something illegal or doing something that you might not like, or is not paying you on time, or if let's say might be some sort of sensitive issues going around. You might be accused of discrimination maybe, and there might be damage being caused by the tenant. So many things, so many different things, right? So we'll look into the tenancy agreement one by one, right? At least the one I have. Hopefully it covers a lot of things. I'm glad I have a good landlord. I hope nothing bad will happen for at least another year. Yeah, everyone just hopes they have a good landlord because they read it, right? The thing is, yes, we have good landlords, we have good tenants. That's the only thing we can hope for. But it's always safe, always safe to be certain of certain things that might help you or might affect you or might be bad for you, just in case something happens. Fate tells you, your time's up, your good luck is up. A landlord is suddenly changed to another person. Maybe the landlord passed away and changed hands, and this new landlord is an ass, and it's gonna make your life a living hell, or you won't have a place to live for the next few months. There's a possibility, right? You have to prepare for that possibility. So that's the thing. Why do both parties need a tenancy agreement? It was very easy. so that both parties know what they should do, legally obligated to do, and what is forbidden to do. Avoid any misunderstanding or miscommunication. I think I have to like do this. Yeah. Avoid any misunderstanding and miscommunication between parties. To be certain what rights does both party have. And that's pretty much the 3 reasons I can think of why you need a tenancy agreement, right? Also, stronger I would say a legal tenancy agreement. A tenancy agreement proof that you are a tenant or landlord, right? So this, what I mean by this is, it's much better if you have a agreement, something that can signify, that can confirm your status, what your position, what your legal position is in this property, right? If you don't have one, there's as a risk of you, or at least if let's say the landlord might say, you know, they want to change tenants, they can just simply evict you without any sort of a problem, without any sort of a issue. They might consider you as secondary, or they might even not consider you as tenant, just someone that have given a license, right? Just given a permission to occupy the place for some uncertain amount of time, right? Especially if you don't have agreement, it could be, they most likely could say something like you're just a month-to-month tenant, right? There's no specific time period. There's no 1 year, 2 year period that it must rent it out to you. That's something that you have to consider. So at any month, it could be interpreted in such a way that at any month, once they don't like you, they could evict you. They can tell you, you know, I don't want to rent to you this month now. You can pack your things and go find a place to live. That's a possibility if you don't have a tenancy agreement. If you don't have anything written down, all these things you have, if you haven't specified, it's not good. It's not good. And there's things like deposits, how to deal with deposits. Oh man, there's so many things. Yeah, we can all talk about it in the agreement. But yeah, in any case, you know, might as well switch to this one now. Yeah, that's what I'm afraid of, but I'm glad I have a place to crash off for a while if it happened. So yeah, this is an actual agreement that I provide to clients when I was still practicing. Right, this really long 20-page agreement. Yes, it's something that would say standard, not more or less standard, and would suffice to explain to people what to look for, right? You don't have to be overwhelmed by this, because I'm good. I'm just even though I'm going to be going to explain one by one of each clause, but I'll explain them very briefly, right? And how to look at them. So first off, we have our cover page. It's not much to talk about the cover page, but to simply put, it's where you first, whenever you look at a document, you like, okay, who is it, who? But it's not necessarily legally binding as well, because fun fact, a legal document that like agreements and such, if they have a cover and their cover is like this, there's some sort of date of up here, and then there's some sort of like a name referring to someone as the landlord or tenant, right? And also the name of the legal document. All this doesn't necessarily tell us anything, and it's not legally binding as well. If let's say you've not signed, if you have not, I wouldn't say legally binding. I would say more like proof of anything, right? Whether there's an actual legal relationship between the parties or what. Well, is this really a tenancy agreement? Because labeling a legal document or whatever doesn't mean that, oh, so this is considered what it is going to be a tenancy agreement. When something's labeled, the contents inside of a document or legal document is not necessarily reflective. So that's why it's, we shouldn't be assuming, oh, this is a tenancy agreement, so inside will all be about tenancy agreement terms and conditions. No, sometimes it could be, that's how sometimes people could defraud you, scam you, right? Inside could be totally something different. We could be talking about promising something else, buying or selling something that you didn't agree on. So yeah, you shouldn't like, oh, tenancy agreement, yeah, okay, I'll sign it, or something like that. Or don't always assume. Also down here, it's normally at least in Malaysia, right? The cover page will also mention something called demise premises. This is normally how we refer to the place that is being rented out, and we would provide a description of it, like what's the rooms that's being rented out, and what's the floor, if it's just by floor, or what's and also most importantly the address of the place. So that's the cover page, right? Now we have the first page, which is a bit more important. It's like if you've seen the terms of service legal document, if you've been my previous live seminars, then you'll understand why I keep telling you this page is pretty important for anyone who wants to start reading any legal document. To start reading a legal document, this is the first place that you should be looking at, because it explains any special terms that will be contained inside the agreement, the document, right? What is specifically defined as not being used in its original definition. We can all find it over here, right? So over here we have this agreement is made, blah blah blah, the date. Then we describe the parties over here more specifically. All right. So I just put name Jake Light here, but normally you would put name, whatever, either passport number or like your national ID number, anything that identifies you as who you are, specifically an individual, or if you're a company, your company number, your registration number, also of course your address, all that stuff to signify who is who, right? Why this is important? It's because you don't want people to mention just a name like this, okay? You don't want to mention a name just like this, Jake Light, because there could be thousands of Jake Light, and it could cause some problem, or most likely there will be some sort of a fraud case if people aren't specifying who they are, okay, specifically. Because fun fact, well, I wouldn't really say fun fact, there's like very old cases, or at least there are always cases with where a person is named very similar or it's the same. They have the same name, but they pretend to be someone without further details of the identification, and a lot of property dealings become void because of that. For example, let's say someone is trying to sell a property, and then someone is at the end you paid all the things to this person, but find out that this person is not really the person. The actual owner is not even aware of the sale, and in the end you paid everything to this scammer, and he got all the money. He disappeared. The landlord still has his property. It's not transferred to you at all, because the landlord the actual owner never actually agreed to sell this property to you, so you're left with nothing. So that's a possibility, right? That's a possibility. Most likely a scam that happens is going to happen like that, right? There's a lot of cases like that where the purchaser, the one that's trying to buy a property, wants to sue the legal owner, wants to sue the property owner because they paid money for it, and they want the property to be transferred to them. But no, impossible, because the first place the legal owner had never agreed to anything, and the money didn't go towards the landlord. So practically they gave money to someone else, and the only way they can get back that money is to find that scammer. So yeah, that's why it's very important to find out who is who, who they really are, and if possible confirm their identification. Right? If we're looking at tenancy, it could happen, right? It could happen. Like say if you wanted to rent a place, and a sales agent approaches you saying, yes, you just have to pay me this deposit, and I'll contact the landlord, blah blah blah, for you, and then you can move to this place. You find out no, the landlord didn't agree to anything, and you paid a big sum of money, some money to this so-called sales agent, and you've lost that money, and the landlord is not renting the place to you. Or even the landlord isn't even advertising that they are renting the place. So yeah, it would be very bad, right? If you're not recognizing if you do not try to confirm whether this person is actually this agent. How can they pay the money without checking the house first? You see then, right? A lot of people don't look at the property itself, especially if it's too out of reach, something like that. Maybe they live in a different state. Maybe the house, they can actually check the house, but they give it the fraudsters, the scammers say something like, oh, because the the legal owner is not there, they have only a representative, and they don't want people to go inside the property. They can only view the property from outside, or some reason like that. People sometimes don't think about these things. Sometimes they are gullible, and they will take it as, yeah, this sounds reasonable. And yeah, there's a lot of ways to scam a person, right? You don't have to go too complicated to lie to people to make them believe you. Some people can't really see red flags, yeah, because people it's because of that's the reason there's a lot of this sort of cases, right? Hopefully in just only in the past, but still, there's still pretty big problem with scammers, right? Even if it's not properties, all over the other different areas, like getting scam calls. That's the most common, right? Getting told that the police is going to or either the inland tax revenue or the government authorities going to catch you because you didn't pay your tax, or threaten you to deduct money from your account if you don't pay this penalty or whatever, right? We have all sorts of scammers. Or like threaten you to to release some sort of like most basic one. If we are talking about us content creators or people who are within the public space, it's most likely there's a chance of someone who is like wants to threaten you to release your personal information out there. If you don't, it will if you don't pay them this amount of money to this account or blah 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 like that. Picking up tax, never mind, I guess that would be another topic. No problem, Isaac. If you want to talk, if you ask something about tax, feel free to ask, right? I've always emphasized that, you know, even if we are talking about a specific topic today, I don't mind going on a tangent talking about other things because I have a lot of time. I have a lot of time. Yeah, that's about identity. So it's very important to identify who is who, right? But for me, for this document, right, over here I put it for the tenant as in the name description is set out in section 1 of schedule 1 with its address, blah blah blah. This is to streamline things because we in practice, right, we deal with a lot of clients, so we don't have time to change all the details in every part of the legal document. So it's we simply, and we, since most we want clients to look at the legal documents to some extent. Most of the time clients would only look at the details. That's where we will point it out to them, and the details would be all put over at the back of the page. If you're lazy to look at the terms and conditions, right, at least look at the terms and conditions over here, right? This is where we put all the specific details like the name, the address, the place of renting, how long the tenancy is, when does the tenancy start, what is the monthly rental. All these details are provided over here in either 1 or 2 pages only. Just curious, if I earn money from rigging commission, do I need to register it as a business and pay tax for it? Same question for Twitch if you're a streamer. Yes. But it depends on countries, right? For Malaysia, you only need to declare it if, let's say, you're earning your earning amount that is higher than I'm not sure what, because there's a threshold. If but then, like, say maybe 3,000 or something like that, depends. I think more than 3,000 or something, 2,000 ringgit. Then you have to declare taxes or something. Whether you're earning it through salary or earning it through your own business, all earnings have to be declared to the Inland Tax Revenue Department. Basically, do online business need to register as a business in Malaysia and pay tax accordingly? No, you can do businesses as an individual, right? Like freelance work for artists and such. There's no need to register a business unless you're like trying to get some sort of like a separate entity for yourself, or like a brand for yourself, for your business, right? But most of the time, if you are doing work as an individual, it's all right. There's no problem with that. But that's Malaysia. As I understand, for Raika, it's much more stricter. You can't just do business. You can't just make money as an individual. You have to register businesses and declare whatever income you're getting. Yeah, they call it income, sorry. That you're getting. Some countries are more have a lot more strict regulations in them. Even if you're not earning this amount, you still have to declare and still have to pay certain monies for it because you're doing a specific business. Oh, okay, noted. I don't have to jump extra hoops to be a freelancer. Yeah, for now you don't really have to consider it unless you're earning a lot. Then yeah, you have to consider whether you want to still. It might be things like how much you're paying for tax, or depends on the business you're doing, because even though taxes there are like stuff on we as lawyers we learn a bit on tax, income tax, or like business tax, or like property tax and all that stuff. There are people who specialize in this sort of things, in calculating tax and what should be declared, what things should be filed, registered. There are people called tax consultants, so actual tax agents who would help you do all these things, make the best decisions in terms of what where you should be declaring all this income, to make sure you don't overpay your tax. But you know, that also could take a bit of it's not cheap. hiring a tax consultant is not cheap. At least from what I've heard, you know, when you're doing a lot of conveyancing work, you talk to all kinds of people and how things are done. Right, so that's about that details. So back here we have this, right? We also, so we don't really talk about specific details. For me, in my agreement, we don't specify all the details. All the details we put it in one page so that our client will be able to look at it in one glance and would know all the details are correct, what they promised, what they need to pay, all that. So over here we have definitions, and we always we always word it in a way to, you know, if you want to know what this is, go to the bottom page, to the schedule page, which tells you everything, right? The only thing we need to consider is there are like statements, and we need to make sure they are what they are trying to say. Like over here, landlord is the registered proprietor or owner of that piece of property, right? We always need to confirm this, right? As conveyancing lawyers, and also as anyone that is looking to rent a place or buy a property, we need to make sure the legal owner is the legal owner, all right, and not some other people. So to make this statement, also as lawyers, right, the first thing whenever we approach with a case, with a file that we need to do, we always make sure the landlord or the legal owner or the proprietor is the person. So to do that, it's a very simple way. Anyone can do it. Is do a land search on the property. Simply, if you have the details of the property, like the land title details, the numbers, the place where it is, you just need those information. Go to a land office, do a search, and they will provide you information on who's the owner, all the details of the owner. Like they are, if they are a foreigner, they will have their passport number. If they are a citizen, they will have their national ID number. And yeah, through that you can cross-reference to who this person is who they are saying they are. And how do I say this? Much better if you have like some sort of actual photocopy of this sort of things as proof. But I'm talking about how lawyers work. most of the time, if for purchasers, for sellers, for tenants or landlords, if they have approached, all right, if they have approached a lawyer, they don't have to think about all these things, because it is assumed that the lawyer has done all the necessary due diligence to make sure this is who we are talking about. Because we are very careful people. Lawyers are very careful people. We don't want, even if let's say it's not our fault that this person is not described as who they are, at the end we might be held partially responsible because we are the professional here. So some things even if we don't talk about it, even if we don't say out loud that we will do, it's assumed to be our responsibility. And even if it's legally right or wrong, we don't want to have it. We don't want the blame to be put on us, right? So we sometimes you could say, yeah, we're doing this for our clients, but we're also doing it for our own selves, in trying to make sure everything is the truth. Yeah. So even at this stage, right, we need to make sure everything is right, everything is true, no one is scamming anyone, and all is well. So that's this. Then we have the basic sentence to say what this agreement is all about, right? So we have a sentence to say landlord has agreed to grant and the tenant has agreed to take up the tenancy of the demised premises for a period specified in section blah 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 blah, as is where is basis commencing on the commencement date blah 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 blah. So over here, this will be the important term where you have to look at. This term, you're going to see it very often, whether you're buying a property or whether you're renting a property, because why do we have what is this about? What does it mean as its where is basis? Well, so basically, if a property is old, it's secondary, blame the lawyers. Well, Isaac, you can try. You can always try to blame the lawyer. But we're very careful people. We're very, very careful people. If a lawyer isn't careful, it's their own problem. But we have, most of the time, anyone who has tried to blame a lawyer, has whatever reason they want to accuse the lawyer of, we have covered our ass. We have covered our ass. Yeah, if you want to blame us for getting scammed, we have protected ourselves. If you want to blame us for not being more careful, we have taken all the steps to say we have been very careful. If you want to blame us for, you know, the rental money is too high or anything, we have all the evidence. We have all the correspondence to back up what we what we have done, right? That's why, you know, I would say some of my quote unquote public relations skills is it comes from having all this experience as a lawyer. Hire another lawyer to blame the lawyer. Well, that lawyer will, if they're smart enough, they won't take this kind of case. Suffice to say, you know, there's a belief that, you know, lawyers just wants the money and such, but they also want to protect their reputation. If they find out, if they know for certain that a case is how do you say, frivolous. Yeah, if a case is frivolous, if a case is pointless to take, it also harms their reputation. Because you have to realize this, right? If a lawyer helps a client to fight these sort of cases, these lawyers are going to meet other lawyers, and these cases are going to be public in a way if they are going to court. And people are going to laugh at you. Other lawyers are going to laugh at you if you take on these cases. Okay, what are you taking these cases for? You're gonna just lose, and losing is not a good reputation for lawyers, right? even if there's like a lot of money in it, right? But yeah, going back to here, as is where is basis. Simply put, properties that are like old, right? They have been around, they've been built for like decades, or even at least been used for some time already. There will be some sort of like damage for them. Maybe the walls is not perfect, maybe there's some sort of smell, maybe there's a some dust, it's dirty in general, or the paint is not new. All the stuff that would make it, you know, not like a new house. And as is where is basis would mean that, you know, once when you first buy this, when you first agree to rent this place or buy this property, you have seen all of it. You have looked at all the condition of this property, and you have accepted as is where is basis. Meaning, say you don't want it to be done, you don't want it to be repaired, you don't want it to be repainted or cleaned or anything. You like it as it where it is, right? So that's what it is. So when the time comes when you do get the property, it is still the same, right? It's still the same. It's not any worse. It's not any better, right? If it's better, yeah, good for you. But it's worse, you can complain about it because it's not what you have agreed to get, right? But you can't say, you know, why is it still dirty or why is it still smells weird? You can't say that because at the time when you agreed to buy this property, it is like that. So that's why as is where space is very important, because in the past it has happened where someone doesn't an agreement, a terms and conditions did not put this term here, and later on the buyer or whoever goes and complain that, you know, why isn't this being redone for me? I want a better condition property for myself. So there will be arguments being raised and possibly threats of legal suits against you as well, right? If the condition is like, if we're practically talking about it, like say there's cracks on the wall, right? Maybe there's cracks on the walls that are like very visible. There's very bad painting, like the paint has been peeled very badly. There's actually blood stain or some unknown stain on the wall that's really bad, right? Yeah, so those sort of things maybe yeah if you don't have this term, you might be in trouble. So that's where S is where is basis. And I would say this isn't that important. Like say, so upon 3 months from commencement of date, the tenant shall pay monthly rental specified blah 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 of schedule. So this is like just telling you when you should start occupying the place and when you should start paying for the monthly rental. Okay, all this is very important, at least from in your mind, right? When you should be paying, when you should start going there, start staying in the place. And sometimes, all right, this is a optional thing, but sometimes the landlord will give rent-free period for the tenant. In most circumstances, if the tenant is going to be living there for a couple years or more, or they have a renewal term for more periods of tenancy. So sometimes, let's say the tenant is going to live here with their family for a long time, or if it's not just a house, it's some sort of a shop, a store, a office, people want to have time to renovate it, right? People want to have time to renovate it. It's a thing that a landlord can give the tenant to do so, right? If they are kind enough, they could do something like let them have a few months free to do all the necessary work. This is a possible thing that a tenant can propose, can argue to get, right? So take that in note, right? If you have a family, if you have a business, well, if you have a business, you probably know this is a thing. So for most people, for most individuals, this is something that probably people don't think about or would consider have the option to propose. So yeah, rent-free periods depends on the landlord always. This is something that has to be negotiated before you go and sign this agreement. Most likely during the negotiation stage, as well as the booking when you sign the booking form with the sales agent or tenancy agents, right? So that's stuff. Yeah, you could say that for the purpose of carrying out renovation work, or you don't even have to say anything about it. But it's good to put it out. It's good to put it out. Then we over here, interpretation, right? This is pretty standard things for every agreement, every contract. So we can't say there's like a technical loophole to get out of anything. Even though if a judge with some rational thinking, some logical thinking, they would imply certain things so narrowly, so interpret things so narrowly. So for example, if let's say a word is using masculine gender, or like it's not neutral, I think this is not right. This is not right. Neutral, yeah, I think this should be neutral. Neutral genders, blah blah blah, all this stuff, how words should be worded, if they are plural or not plural. It should all mean what it means. Typo in a contract, shaking my hand. Yeah, it's very very normal to have typos in an agreement. Where there are so all this is pretty standard stuff. But one thing you have to look in, I would say, is when there are terms. I would say this is important in the tenancy agreement. Do take note of, like, say if there are like notices, right? When you have to give notice to someone, whether you are terminating the contract or you want to renew a contract, there's like notices. Yeah, I make a typo in a report at my workplace and already got told off. But I can tell you, as lawyers, right? We are, even though we are, sticklers for rules and such, we are not sticklers for typos, because we're professionals. We know how to read. We know what sentences are implying, even if they are like typos, because how do you say? If in the event these documents go into court, right? It's not like for just because of a typo. Oh no, if your case is gonna crumble or such. If it's like that, oh man, there's so many. We don't take words literally. Is what I'm trying to say, right? The court system, whatever, we don't take words literally. It's just that some people have maybe are very sensitive with certain things, and for us it doesn't make sense. It's just people who are like, everything has to be correct, even the words have to be correct. For us, we just want to get things done. We just want things to get on with. As long as there's no legal consequences, as long as legally safe, as long as the same intention, same meaning can still be construed, can still be interpreted, just leave it. All right, life is not worth worth it for all these typos to worry about, right? There's so much more things to worry about. Why worry about typos? Well, of course, then again, it can't be too ridiculous, all right? It can't be too ridiculous with typos. It shouldn't be like every other sentence there's a typo. Okay. But of course, if we find out typos, just correct it. And in the future, it won't be there anymore. Yeah, I hate my job. Yeah, there's a lot. I see this is a problem with a lot of other companies, but for law firms, our bosses, our seniors, we are all lawyers, right? We are all lawyers. So we understand each other, and we understand what it needs to be done, what needs to be efficiently done, what affects things detrimentally in a legal sense. So yeah, there's no need to argue over all these things. But typos are typos, but using a different word, right, is very different. It's much more serious. If I have to clarify this, using words is different words for a sentence to mean something could change the entire thing. Could change the entire legal consequence. So for those things, we need to be very, very careful, right?
Stretch.
Oh, thank you for the stretch, Arion. We need to, because things like may, or things like shall, or things like in the event, or provided that something, all these words, if they are there, right, it changes your legal obligations. It changes what you should be doing, and changes your rights and all the things in a agreement. A few words, a few phrases that is not worded carefully could cost clients big chunk of money, a big chunk of money. You thought you thought this is okay to write in this way, but at the end, when you think about it, how this sentence is interpreted, and can only be interpreted, is going to be very important. That's what us lawyers is more focused on. We don't care about typos. We only care about what the sentences mean. What do they convey? What do they want the parties to do, legally do? The consequences, all that is very important, more important for lawyers in a legal document. So yeah, let's continue then. All right, so let's go move on. And we have here just a simple, again, we have to reiterate what we have said earlier, because the above is most like just an introduction. So in here, we again say that the demise premise is as is where its basis, and upon terms and conditions herein contained. Right, we always have to tell you, sometimes we repeat certain things, right? So, or sometimes people who I've not seen this happen in court, but I heard lawyers argue about that. The second page of the agreement is just an introduction. The only main content inside the agreement is here, so they have to again repeat the things that was said above there. But I understand. We have to be very certain. We have to be very sure on certain things. So some things have to be repeated. And we have the tenant. All right. So over here, section 3. In consideration of the tenant agreeing to pay the rent and other monies payable to the landlord under this agreement, and further agreeing to duly observe, comply, and perform the terms and conditions hereafter contained, the landlord agrees to let, and the tenant agrees to take a tenancy of the demised premises on an as-is-where-is basis for the term commencing on the commencement date, subject to the terms and conditions hereafter contained. Yeah, so we're just repeating here. Now we get to something new, deposits, right? We have a lot of like important terms which we put in front, and how we draft agreements, right? Most of the time, how we draft agreements or contracts, we take it step by step. We take it step by step, and how things are to begin and how things are to end. So you can say that in real life, right? Agreements, contracts, they are worded like a procedure, a guideline that is step by step. First, you do this. Second, you do that. Third, you do this, or etc., right? Or you could view it as some sort of story, right? This is where we begin to do things. In the middle part, this is all the main crust of whatever story we want to tell, the main issue we want to deal with, and then at the end, how do we tie up all loose ends, how it ends, what the ending is like, as such. So I would say, yeah, it's a good tip to how to read a document. You can just read like any sort of a story, except it's really technical and all legal jargons. So yeah, deposit. The tenant shall pay the landlord a sum stated in the blah 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 security deposit for the due observance and performance by the tenant of all terms and conditions, stipulations and covenants on the part of the tenant to be observed and performed herein upon the execution of this agreement. Right, so tenant has to pay something, which we referred as security deposit, and we only in like general terms say what this is for, but below all the terms here, we're going to tell you, yeah, this is going to be used for what? A very boring story. Well, a boring story that involves you in it. I said, if you're a party to this agreement, it involves you. So you're quite literally writing your own future in a sense, or your own presence, or your own present time. So, ignore at your discretion of this boring story of yours. Yeah, so in addition to the security deposit, the tenant shall also pay to the landlord a sum as stated in Section 8 of Schedule 1. So this is how, did it tell you how other than security deposit, right? So we have another kind of deposit. So sometimes, or say not sometimes, most commonly, there's two different kind of deposits. Right, one is called security deposit, one is utility deposit. The utility deposit is specifically for supply of water, electricity, sewage, so utility stuff, like for maintaining the property. There's not even a plot for the story, shake my hand. The plot is you're getting a property, and how you're getting a property is determined in the story, and how it ends as well. Or how the story can end badly for you if you don't follow the story. what are the consequences if you don't follow the story? Can think of it like that. Payable by the tenant on or before the execution of this agreement, and landlord reserves the right to increase the utility deposit from time to time if and when the usage of utility per month exceeds the deposit. Right. So this is how we determine what's the security deposit, what's the utility deposit. Sometimes it will put in like that, where this is more for the landlord, and this is kind of like optional thing, not necessary. Whenever you look at terms, right, if you don't like it, you can say you don't like it, and we can both parties can negotiate whether this is something you want to put in or don't. Like over here, it says utility deposit can be increased if let's say the usage of utility per month exceeds the deposit, right? So it makes sense for it could make sense for the landlord, but it could not make sense for the tenant. Can be discussed, not necessarily confirm or concrete, or it has to be this way. Because as long as you haven't signed the agreement, haven't signed the contract, things can change, right? It's just a word file, right? It's not like, oh, it is fixed or anything. There's no such thing as fixed contract, unless you already sign it. And then if you already sign it, if you want to change terms and conditions in it, yeah, you have to have a problem now. You then have a problem that you will want to try when you want to try and amend the contract in the future. Right, so deposit to be maintained, we have this. Deposit shall be maintained by the landlord at all times during the term hereby created as security for the due observance and performance by the tenant of terms and conditions of this agreement. Provided always that landlord may at any time make such deduction from the deposits may be sufficient, whether by way of compensation for any damages or otherwise for which the tenant may be liable under terms hereof, but without prejudice to the landlord's right to any further sum for which the tenant may be liable hereunder. It's a really, really long sentence, but it's basically telling you that, the landlord could use the deposit to compensate them for whatever is happening on the property. I'm free and semester is done. Ooh, congratulations, Arion. Yeah, but still want to take a break right now because critical mistakes and the fault I got. Semester is done, you're free, but you want to take a break. But that doesn't make sense because you're free. Shouldn't that make you already mean that you can relax already? And what critical mistakes are you talking about? When you're done with the semester, anyhow, hope it's nothing too serious, Arion. So yeah, long sentence, but just to tell you, landlord can deduct the deposit in case some terms in this agreement has been breached, or like say we will look at it, all right, in over here, but it will tell you, let's say something like if you haven't paid your rent, they could forfeit your security deposit, or if let's say you cause some sort of like a water leakage or cause some sort of like a electricity problem maintenance or anything like that, they could deduct your utility deposit, all that stuff. Deposit shall not be deemed to be treated as a payment of rent or set off against any arrears of rent or for any other payment due from tenant to landlord. So yeah, this is something I would say very important to take note. If there's a term like this, it means that if let's say you, the tenant, you're not paying your rent, right? And the landlord decides to, terminate the contract because you're not paying rent, but also forfeit your deposit. It doesn't mean, right? It doesn't mean that you don't need to pay off the what do you say? Time to sleep. Take care, Jake. All right. Good night, Aaron. Good night. Hope you have a good rest. It doesn't mean that you don't have to pay your rent anymore. But most of the time, yeah, when the tenant just leaves or disappears, it's very hard to get the money from them again. But you are still legally liable to pay the missing rent that you didn't pay, right? Because the deposits aren't treated as an offset, right? A set off against any arrears of rent. It's not the deposits are not being deducted because of the rent, right? The rent is like the deposit is acts like a deterrent for you to not pay the rent, because normally, if let's say someone stops renting by complying with all necessary terms and conditions in the agreement, like say because of the expiry of tenancy, they should get back the deposit, right? The deposit is not owned by, is not, how do you say, paid to the landlord. It's only kept by the landlord as security. It's like insurance for them in case you disappear. So yeah, that's it. The money should go back towards the tenant, right? When all things are done and completed. So that's that. Refund of deposit. Yeah, so that's why this entire clause, upon the termination of term hereby created by the inflection of time or otherwise, and provided all monies due hereunder have been duly paid on the due dates and other terms, covenants, and conditions have been duly performed and observed by the tenant, the landlord shall subject always to section 8.01 hereof, and or subject to satisfactory inspection carried out in accordance with refund to the tenant and deposit free of interest, less such sum or sums as may then be found to be owing to the landlord pursuant to the terms of this agreement. So yeah, this is what I just explained right just now. It's either sorry, either the time has expired and or all monies that is due to the landlord has been paid. So maybe most likely the rent, right, for the tenant has been paid to the landlord. Then the landlord will refund, all right, will refund the deposit. After checking everything, of course, safe, satisfactory inspection, checking everything is still fine. It is as is ways. Probably hasn't gotten worse, and it hasn't gotten worse because of the tenant, all that stuff. Yeah, so they will refund the deposit. And why? Normally I could speak for hours and hours, but for this one, my throat is getting sore just from having even gone through like what, halfway through all this agreement. But I'll try to fly through this much faster, because this is not necessarily very hard to understand or very important to emphasize. So yeah, we'll go through things that are unless like the terms and conditions are very specific things that I need to point out. I'll only point out whenever I can. Go drink tea instead. I don't know. Is tea going to be useful? Anyhow, forfeiture of deposit, right? Simply put, yeah. If let's say there's a breach, right? There's a breach of terms and conditions, the landlord can forfeit this money, all right? The landlord can forfeit this money. And of course, they can still chase for the rent that has not been paid or anything else that the landlord has suffered, right? Normally, this means like you've heard stories where the tenant is not in good terms with the landlord. So instead of not just paying the rent, they go and destroy the property. A worst kind of tenant, right? They destroy the property. They break things. They break the maybe the toilet. They break the walls. They break the floor, windows, just out of spite, and then suddenly disappear. So that's a possibility for landlords as well. So deposit might help, but really, if things like that happen, it's a lot of repairs have to be done, and hopefully, it's worth chasing back the tenant to cover all this loss. It could also, I would say try not to do these things because it could be considered as criminal offense as well, like intentionally damaging properties. Anyhow, then we have guarantee. This one, it's a bit more optional. This is something that if you're renting to a company, right? If you're renting a shop, a store to a company, this is much more important. Suffice to say, it's basically having the company's directors or someone that is very up there above, like CEO or anyone, to furnish a letter of guarantee, so that if let's say the company doesn't pay for the rental for one reason or another, we at least have the individuals, the directors, to be held responsible to pay off these things, right? Personally. So this is kind of optional. It's optional. It doesn't apply to people who are company. So that's why we put it here. In the event that the tenant is a company, and only then you will provide this letter. And of course, this letter would be drafted by us, right, and given to the tenant to sign. And of course, over here we talk about the rent and how it should be paid. This is also very important, when it should be paid, right, when it will be due and all that, but very short considering everything. Like here it says tenant shall pay the landlord rent in advance, which sums shall be payable exclusive of rates and other outgoing clear or all deductions or set off the first for such payment to be made on the commencement date. So usually how this is done in a proper tenancy agreement, when a tenant wants to rent a place, it's good gesture. It's good. It's I would say good gesture and good practice for tenants to pay first before occupying the place. It's a way to say, yes, I'm serious in occupying this place. I won't suddenly disappear, right? This is sometimes even the deposit isn't enough. That's why you could say this is optional. It's not necessary, but sometimes it is necessary. Commonly, at least within where I practice, advance rental is normally paid before even moving in the place. Then, of course, once you start living in the place, over here it says subsequently payable on or before 7th day of each succeeding calendar month. So this could be different for other people, but yeah, in general, it should be paid every month on the first week, right? This sort of rental payment, it shouldn't be delayed too long, right? And all this has consequences, right? As we have seen, all this has consequences. If you don't pay in time, it's considered a breach. And yeah, at least, over here, the forfeiture deposit will happen if you don't pay in time. Unless operations shall be affected by way of bank draft. Yeah, so this is also telling the tenant how it should be paid, all right? But this is, it could be paid, this is interchangeable in the sense, or you could pay it like cash, online transfer, specifically on what bank account. You could say it's just for, you can only use checks. But for this one, bank draft, I don't think people often see the word bank draft. This means that I would say for companies, it's more often when you see this language use this type of payment for companies. Bank draft means that it's similar to checks, but in a sense, this is issued by the bank. This check is not made by the company or the individual. The bank itself themselves are paying out this money on behalf of the individual or company. Meaning to say, if let's say the individual doesn't have any money, or not necessarily not any money, or if they are check, if their own personal saving accounts doesn't have any money, maybe, who knows what the reason is. With the bank draft, the money isn't necessarily coming out of the individual company's own savings account or whatever account they have. It's actually coming out of the bank's account themselves. That's why sometimes landlords would prefer this kind of payment. So there's no chance of getting scammed or the check getting bounced. Right? If the check gets bounced, it's the bank's fault. It's not the individual or the company's fault. So you actually see this very often for companies, at least when I practice. But yeah, it can be anything else. It doesn't have to, this sort of wording doesn't have to be like this, right? Money, online transfer, even touch and go payment, if that's what, or like online wallet, all that kind of stuff. Yeah, you can use those as payment method instead. Right, so now we come to the covenants by the tenant with landlord. So this is the part where the do's and don'ts come in. They are kind of like community guidelines when you think about it. Well, community guidelines for the tenant, right? When they are in the property, when they are renting the property, what they should do, what they shouldn't do, all that stuff is over here. Of course, there's also a section for the landlord as well. So it will say covenants by the landlord with tenant, right? So of course, we have here the first one, payment of rents. Yeah, so it's just reiterating again that tenants should pay on time, right? Mentioned above. The tenant, where it should also mention what the tenant is using the property for, using the demised premises for. So if we mention like this property can only be used for residents, and it can only be used for residents. You can't go and suddenly open a shop or open a some very sus business, or yeah, in general use it on a commercial basis, right? You can't turn you can't turn the house into a studio where you're like recording music or something like that, which would affect people, your neighbors and such, or start selling food. Turn it into a cafe or restaurant, something like that. Oh, thank you for the raid, Kuta. Hey, thank you, Isaac, for the shout out. Kuta's to sleep, sleepy raid. Kuta's to sleep. Are you sleepy, Kuta? Sam, hey Sam. Sleepy raid. I'm guessing you're sleepy now as well. How was what was the game you're playing? Star Fox. Ooh, Star Fox. How far have you gotten through that game? Have you finished that game? Oops, man. Oof. Yeah, it's a bit late. Yeah, it's a bit late. How are you, though? How are you? Also, thank you for the raid. I'm pretty sure most Guta, Dusk, everyone, the gang knows me, but for courtesy's sake, I'll introduce myself again. Hello, this is Jake Light, gaming lawyer at your service. I am a real-life lawyer as well, so if you have any legal questions you want to ask, feel free to do so. Right now, we're doing a live seminar. We're talking about tenancy agreements. If you have any question regarding that, feel free to ask as well. This is where the best of times to ask these things. Yeah, I'm very tired. The game is going well, though. Oh, I see. So if you have to go to sleep, all right, Kota, go to sleep. Right, have a good rest. Well, we can always talk with each other anytime, anywhere. All right. Thanks for the rate. So yeah, I'm doing a live seminar on this one, and right now we are looking through a tenancy agreement, which when I used to practice, which is I specialize in real estate laws in Malaysia. So this is actually an agreement that I used to use for my clients, and yeah, we're going through terms by terms and seeing what they mean, what they're used for, what's their purpose, and if anything important we need to take note of. Right. So, but of course, anyone can ask anything, right? Whether it's legal, whether it's not legal related, because right now live seminar is I would say a much more interactive session right now. The best time to have ask questions, the best time to discuss things, right? Because I'm also doing this specific topic because a lot of, I would know, probably most people from the United States are renting a place, are not buying a place. So this could be very important information for people over there as well. I would say important for everyone everywhere, because pretty sure not a lot of people are able to afford property themselves, like buying property themselves. And even then, I wouldn't recommend buying properties because of the quote-unquote eternal debt that you will be in. But yes, other than doing live seminars, I am a variety content creator. I do all sorts of things as well. I play games, I draw stuff, and do voice acting, do ASMR a bit, and also right now that's pretty much it. Anyhow, again, thanks for the rate, Kota. I hope you have a good night, good rest, a good night. So where we stop over here, so we stop over here as use of the premises. We need to make sure that whatever we are using whatever property we're renting, whatever house we're going to be staying, we need to make sure it's only being used for that purpose. So if you state it is for residential purposes, then you can only use it for residential purposes. You can't go on and turn it into a store. You can't turn it into an office. You can't turn it into a restaurant or cafe, anything like that. So yeah, don't do that unless it specifies for any use. But normally depends on what the property itself, what type of property it is. If it's an apartment, surely they won't let you do it, even if you say you can do it. Oh, I need to change this music. It's a turning music. Oh, it's a long music though. Okay. Property is quite expensive, but thank you, Jake. Have a good rest of stream. No problem, no problem. Because yeah, property is expensive here as well. I wouldn't say it's cheap. Why if I rented the room that I rent to another person with a higher price? You can do that, provided the landlord is okay with that. Since I know, Isaac, you say you don't have a contract, which would mean it's a yes or no to your question, whether you can do it or not in the first place. You can rent it out at a higher price, no problem. But that's the thing, can you do it in the first place is another question. You found a cheap one without contracts. Man, Isaac, you're digging yourself a deeper hole, and you're an adult. You can do whatever you like. I do not necessary. I can do anything about it. I can only advise you not to do it as a friend. Yeah. So about the, it's a good question, really, Isaac, about whether you can rent to another person while you're renting. Basically, it's a question of whether you can assign your rights to another person below you, right? That's called sometimes it's called sublease, or it's called sub-renting. In a way, it's legal. You can legally do that, right? But whether, because you don't have a contract, whether you can legally do that, it might depend on whether you might have to like get confirmation. You get written formal confirmation from the landlord for you to do it, or because it's a mess. It's a gray area. It can be argued either. It can be argued both ways, because you have no idea what all your rights as a tenant is, because as far as I know, there's no specific laws regarding on implied rights for a tenant in a such a situation, right? There might be laws or there might be regulations regulating this sort of situation outside of Malaysia. I'm pretty sure there is, at least in the United States, right? They are very particular about renting stuff. But in Malaysia, the laws is quite lax on this. As far as I can tell, there's no such strict rules in regards to rental, because we follow the English system, the Torah system. Anything about rights, right, over property should only be found through the the government department, where they keep all the records of legal rights of a property. And as far as I know, a tenant doesn't have a legal right per se that can be registered in our system, in our legal system for properties. Anyhow, let's continue. So prohibition, you've used amounting to prohibition. The tenant shall not use the demised premises or any part thereof in such manner so as to cause the accumulation of dirt, rubbish, or debris of any sort of in or outside the demised premises of any unreasonable noise, and shall not place or leave in the entrance or corridors of the demised premises, or boxes or rubbish or otherwise incumbent. Yeah, so this is like what you can do and can't do in terms of like keeping the place clean. Okay, don't make it dirty. And we have like, illegal and immoral use. So don't do things that could be considered illegal or immoral or contravene any laws, bylaws, acts. So yeah, it's very simple. I don't really have to explain this. Don't do illegal things in your property. Don't do drugs. Don't do weird things in your property. Prohibition of use. So there's a lot of things over here. This is much more concerned with whether this is, so most of it is like can't really use this for anything other than residential. But to be specific, we put in all these things, not even just residential, or things that some businesses you can't even do, or trade you can't even do, even if, let's say, this property is a commercial property, right? So funeral parlor, I believe everyone knows what funeral parlor is, right? Using it to like do all any sort of business in regards to like selling coffins, or doing sort of like selling burial stuff, or like ceremonies and such. Bruh, when you say that, we have a lot of businesses that is a lot of funeral parlors businesses around in Malaysia, here and there, and we don't want that to be a lot of like, at least a lot of landlords or a lot of legal owners don't want to turn a commercial hub into a place that people don't want to go near. You would do cremating in my room. I said, don't joke about that. But regardless, cremation isn't done in these sort of places as well. Cremation is very specific. I would say in very specific properties, you can only do this sort of thing as well. Sorry, no problem, no problem. It's okay, it's okay. But yeah, how do I say this? Funeral parlors, you don't see it in major commercial hubs, at least. Okay, you might be able to see them in like corners, people where people rarely go towards, and they don't really advertise, or they don't put out coffins. Some places do have, some places don't. But most of the time, if let's say there's like a restaurant, there's a restaurant within that street, there's cafes, restaurants selling food, or convenience store. Having a funeral parlor next to them is very bad for businesses, for everyone, especially in Asian countries where a lot of people have superstitions. They're superstitious. How do you say? Would think it is bad juju. For this sort of business to be around, to be near these places, right? It's not illegal. It's just that not good as a image for a place. It's good to have superstitions, but not let them control you. Yeah. That's it, right? Superstition. I would say Malaysian superstitious. I would say relatively speaking, compared to Western countries, I would say quite superstitious. It's kind of disrespect to the dead. Yeah. Kind of disrespect to the dead as well. Even though, people selling coffins, there's nothing inside the coffin. It's not something that people want to see. Even if we are not superstitious, right? Even if we are not superstitious, practically speaking, we don't even want to look at coffins because it reminds us of depressing things, right? It could be traumatic for some people looking at coffins, and we are not expecting to see them, right? That's one thing, right? A more practical reason why there shouldn't be this sort of like business to be opened in especially crowded areas, crowded commercial hubs or towns and such. Thinking about it, the place where I live, the funeral parlors, yeah, they are very far away from any hotspots, at least. But considering Malaysia's superstition, I would say the only thing that's very common might be that, like say, for high-rise buildings, you won't see fourth floors. You will be able to see 13. You won't be as in the fourth floor won't be numbered 4. It will be numbered 3A or something like that instead of number 4, because of the number 4 means a lot of means death in a lot of languages in Malaysia, especially Chinese. But quite interestingly, for some, it's good. It's good number for people. For some people, like for Malays, the number 4 is good because in Malay it sounds like getting more. The word more things, or like receiving more stuff. So that's why you will actually see car number plates. A lot of car number plates having 4444, 4 numbers. Which I think no Chinese culture, people who are deep in the Chinese culture would actually have as a car number plate for them. But that's it. We have floor 13s because we don't have the we are, I think number 13 is like Friday the 13th, right? And we don't have that superstition here because it's not a known thing, or it's not old, I would say. As in, I think it came from the movie only, right? Friday the 13th is a movie thing, right? That's why it's not something quite relevant in our country. And superstition, I would say, other than that, it's more towards feng shui then. In regards to properties, a lot of people would really look into the feng shui of properties so that if their prosperity, their luck, or their businesses would be very good, right? It's, meaning, say, if let's say the room, the property is facing a certain direction to the north or whatever. I'm just bullshitting. Right? I have no idea what is right, what is wrong. Or like if we put this sort of a fountain in your room, in your property, and facing this direction, enough money will go through you or something. That sort of superstition we have a lot as well over here. Even my own family have this sort of superstition as well. Like we have a superstition where we have a belief that if you're sleeping, right? If you're sleeping and your bed is facing the gate, the entrance of your home, is considered bad luck or something like that. I forgot what the actual reason is. It might be because, you know, it's believed that people who have passed away or something, they rest in that direction. Their feet is pointing towards the entrance, and so that it's not good for people who are sleeping to have their bed facing in that direction. Oh, interesting. Never heard about that. Or yeah, I'm not sure if it's a very prevalent thing or common thing, but it's what my parents used to talk about. That's why none of our beds are facing it's facing all kinds of direction except my voice except for the entrance, right? It's not facing any direction but except for the entrance. So anyways, enough about the funeral parlor. We have so many other things to talk about. So funeral, and then business or trade in connection with the supernatural or occult. We don't even want that. This is okay. Again, this is just a sample agreement. All right, don't take it as precedent or like law or anything. Something you might not agree to, some things you might agree to, but this is just a general list of things where you can't use it for in a property. Setting up place of worship or prayer in the respect of any cult, religion, or beliefs. Yes, we've used the word cult because fun fact, Malaysia doesn't have anything. It's not illegal to be in a cult per se, because we have cults in Malaysia, actual cults, right? Not just being accused of cults, but actual cults in Malaysia. Fun fact, personally, when I was younger, what, most likely 2 decades ago, at least 2 decades ago, I had a neighbor, which it was not used. The place was not used to. It's a how do you say? It's a terrace house. All right. It's supposed to be a residential place, but apparently it was being used as a place of worship, and I believe it's a cult because the things that they chant, right, sounds like Buddhist chants, but no, they're not praying to Buddhists. They're praying to some sort of like some sort of a figure a historic figure. I'm not sure what, but definitely a cult because it's not Buddhist. People go there and they wear uniforms, or I would say uniforms, robes of such, as it's not common. And it was very very annoying because every time there was some sort of event, a lot of people would gather into the room, into the place, into the house, and start chanting very loudly. And I don't remember how long it went, but yeah, the people do use this place, do use properties to go to any residential places or whatever to do these activities. And it's not illegal, but it's very annoying. Then again, if we are talking about civil matter-wise, you can say it's legally speaking, you can sue a person for what you call noise. Yeah, you can sue the person for nuisance because of what they are doing. So yeah, that's one thing. And also religious political activities, this is dependable. This is student Jake student. It happened long ago. I was very young. Now my neighbors are pretty good. They're not cults or fanatics or anything like that. So good. At least that's good. So any business, trade, unpleasant odor accumulated, any business trade that deals with substance and chemicals or explosive dangerous character and their byproducts, gaming, public entertainment, amusement, public or private auction. Yeah, all these things. Massage parlor. We even put this massage parlor. Yeah, fun fact, Malaysia is full. I hopefully not a lot now, but there is still some massage parlor, right? But they are not legit. A lot of them are not legit. Okay, it's a massage parlor. They have some side business they do in them. I would not recommend anyone to go if they are visiting Malaysia to go to massage parlors. Okay, it's not like Thailand. All right, Thailand has like tourist spots with massage parlors that literally they only do massage. They don't do like happy ending or anything like that. Maybe they do have that, but most of it is quite legit. Social escorts agency. Yeah, there's another word for brothel. Any immoral, improper offenses or unlawful activities, or brothels, setting up of places for direct marketing or any other related activities pertaining thereto. Right, direct marketing. This could mean things like a lot of Malaysia, a lot of places in Malaysia have these places where they sell certain products that are like placebo effect, but they are very very expensive. They are like a cult themselves, and they don't not only sell stuff, they also like try to get people into becoming members. It's like an MLM thing, right? But much worse. They scam old people most of the time with like cure-alls and such. Massage, quote unquote massage parlor. Yes, I said. What's with that face? Don't tell me. Did you? Anyhow, moving on. Medical or dental. Yeah, this is really not something. You can put in. You don't need to put in. Hair salon, beauty salon, workshop. All this stuff is optional. It can change depending on what place you are doing, what place you're renting out. Pet shop or any business related to animals or related activities. Right? It's not over here, right? It's not said over here, but you could also let's say you're a landlord. Bruh, of course not. Bruh, of course not, but also with a face. You could also put in like, if you're a landlord, to say that you don't allow pets, something a landlord can do as well. Even if, let's say, it's a landed property, most of the time if it's apartment, it's a flat, they would already have apartment policies to say that you can't have pets in the place or something like that. Right, next, upkeep and maintenance of premises. So this is another very important thing to take note. This tells you who is responsible for what and what is to be paid. So over here, at least for here, tenants shall keep the interior of the demised premises in good, clean and tenantable repair and condition. Normal fair wear and tear accepted. So over here it means that, you know, property is supposed to be on an as-is where-is basis, but it doesn't mean that you can damage it or just not clean the place that you are living in. You have to, you know, take care of yourself and your surroundings. It's basically what this is about. All right, don't damage the equipment provided by facilities provided by the landlord or any by the landlord over the property. And shall replace or repair any of the aforesaid items and any part of the demised premises which may be broken or damaged or become defective due to any act, default, omission, negligence of tenant, its servants, agents, or invitees. For the avoidance of doubt, the tenant shall not have the duty to repair the toilet and electricity box of the demised premises. So all this, you know, it could say this, landlord could say this, landlord could not say this. Yeah, so just, I would say the advice here or the tip here I can give for anyone is, this is something that can be negotiated. If we find it not satisfactory, if we find it unfair or unreasonable, or you want to add, or if, as the landlord, you want to add more things into this one, you can, but also, again, negotiable. What I'm trying to explain throughout this agreement is that there are categories. That all these terms, all these costs and terms, just view them as categories. So we have like a category for things you can do, you can't do. We have a category for how you can pay rent, how much you can pay rent, when you can pay rent. And we have category for deposits and what deposit can be used for and how it can be refunded or forfeited. Yeah, think of all this in your mind when you're like going to rent a place or going to rent out a place, so that you know what to make sure you know what you want when you get into this sort of a property. Not just how many bedrooms are there, how many toilets are there, or whether there are Wi-Fi, internet for that property. Those things, you know, they are your concern, but all this is also very important. Very important to know. Right, then we have installation of equipment, but they are the most important. Everything is important, right? I would say, even if, let's say, you're not buying a property, just treat renting a place as if you're buying a property, because you're living there, in the sense that your life is there right now. Even if you don't own the property, you're living a life at that place, at that time, right now. So how your life is, how satisfactory it is to live over there, and safe it is for you to live there, it should be your concern as well. So for me, it's, yeah, whether you're buying a property or renting a place, it's good to try and treat it as your home as much as possible it can. But with at the back of mind that, you know, you have to deal with the landlord. You have to be careful with the landlord. So much work just for renting. I need to look at multiple places as well. Yeah. I can't say it's an easy thing to do, right? That's why when Raika was looking, that's why, yeah, you heard her how it is so troublesome, for how difficult it is for her to suddenly not find out that she's not going to be staying at the place that she's currently staying for longer. It gives so much problems with people for when this sort of things happen, like getting evicted, right? Just because the landlord has so much more power, so much more bargaining power and authority and rights over the property. The least a tenant can do to, you know, prepare themselves is know very well what their rights are as a tenant, right? So that when the things do happen, when the worst case scenario happens, you have contingencies, right? It's a possibility that this will happen. If it happens, what am I able to do? Do I have a backup plan? Is there a way to interpret these terms and conditions to my favor? Did the landlord actually do something correct? Did they actually follow procedure or not? All things is very important to know. And you know, if you don't even have a contract, worse, you have nothing. Your life is at the hand of the landlord, quite literally, right? The landlord decides your fate, whether you stay here or you don't. And moving is not fun, right? Moving here and there is not fun. You get cozy, you get comfortable living in a place, and suddenly your landlord tells you, no, you can't get comfy anymore. Go find a place and use whatever time you need to adapt to that place again, and then hope you're going to stay there for long, right? That's always the problem with as a tenant. It's a con for tenants, but there are also pros for a tenant, right? Living like this, there are pros and cons to it, depending on how you see it and how your life is like, right? What you desire in your life. But anyhow, let's continue. Installation of equipment. So this is another thing, right? All this is part of the covenants again. All of this is what you can do, what you can't do, and we have to specify everything, right? Specify everything. So there's nothing we haven't actually talked about, nothing we haven't covered, and if it happens, we have something to look at. That's the purpose of the tenancy agreement. If something happens, you at least have the agreement to tell you what you should be doing, what your rights are. So over here, installation of equipment. This over here is just basically if you want to make some sort of like specific modification or renovation work on the property. Over here it tells you you can't unless you get permission. The tenant shall not make or permit or suffer to be made any alterations in or additions to the electrical installation in the demised premises, nor to install or permit or suffer to be installed any equipment or parameters which exceed the loading of the electrical installations in the demised premises. So this is more specific to electrical stuff, electrical devices. Maybe changing the electrical ports of the property, or adding more changing the shower device, or changing the fan, or using any electrical equipment that might be too hard for the property to handle. Yeah, these things might be very niche, might happen rarely, but it's good to have them, right? It's good to have them just in case. Then we have prohibition of nuisance. Yeah, don't be a nuisance. So this nuisance could mean anything, right? With the interference of quiet and comfort of the occupants or the adjoining buildings and or affect their activities on the demised premises or any part thereof. So this is a good thing for landlords to say that, you know, don't do things that a tenant the tenant shouldn't be doing things that are a nuisance to their neighbors, because a nuisance is a civil wrong. Can be sued, right? The landowner can be sued, and in turn, the landlord would sue the tenant for something like this. And we have noxious, dangerous, and hazardous goods. I don't really have to tell you, you know, you shouldn't be putting a lot of dangerous stuff in your own home, even in your own property, right? Even in your own home. Something you should be doing. Also, why is there no music? Oh, yeah. Let's just play some. Man, my nose is itchy. I'm gonna do something about it. I'm back. Yeah, don't put dangerous stuff, right? I'm pretty sure this is something that people won't do. But then again, you know, you never know. That's why we always put all these terms inside. All these, any terms. Like say, maybe I would say if it's Malaysia, don't put dangerous things like what would be a dangerous thing? Fireworks. But even though fireworks are illegal, right? Fireworks are actually illegal in Malaysia. But you know, our government opens one eye, closes one eye kind of thing. How about a machete? Are you selling machetes, Isaac? Why do you have a machete? Anyhow, but yeah, this sort of things is very broad. I wouldn't say very broad. Not really broad. It's very specific. I don't think people can argue that, you know, this includes like knife or such. I would say it is more towards maybe barrels of chemical stuff, or like very flammable stuff that could be very hazardous, right? Not necessarily things that would explode, but things that would get caught in fire very easily. It's considered as a tool. Yes, if you use it to cut coconuts, right? Yeah, can use it as a tool, right? Don't use it in any other way, right? Section 6. All right, so permit inspection repairs. This one I don't really need to go into too much detail, but basically this provides the rights to landlord to inspect the property, and with this specific term, it's more towards the tenant allowing the landlord to let the landlord to inspect the property, right? For many reasons, one of it being to, let's say, to do repairs on the property, or if, let's say, the place is being rented to multiple people and there are potential tenants to be rented into the property as well, you allow them to be inside as for these people to check through the property. So that's something. You have to allow the landlord to reasonable time. You have to work out reasonable times, or like make appointments or something to all do all these things. You can't just, you know, bar the landlord from doing all these things to check their own property. because that's why we put it in here, right? We put this section in here so that it's not something like you can not expect it. Something either the tenant is not expecting to do, or the landlord doesn't needs to tell you every time, or like specifically how it is to be done. Because over here it's already covered how it is to be done. Like, do you give notice? How do you tell the tenant that you're coming in? All that stuff. I'm the landlord now. No, doesn't work that way. Doesn't work that way, I said. So yeah, this is very important, right? How this is worded, everything, it's up to you. But then again, if it's not worded about you, the agreement is not drafted by you, hopefully there's something about this in the terms and conditions, right? In your own contract. And we have permit laying of wire and pipes. Tenant shall, upon receipt of prior written notice from the landlord, permit the landlord. Yeah, so this is again something where in relation to letting the landlord go into the property to do works, to fix something, to repair things, all this stuff. And we have restriction against alteration renovation. So this is more to, yeah, tenant can't just simply renovate the place, but of course this is worded in the way that if you do want to renovate, then it requires landlord's consent. This happens very often, for at least in Malaysia, at least for the cases that I've dealt with, is that a lot of people who wants to rent a place wants to also renovate it. A lot of like families, right? That are not buying a property, they want to renovate it. Yeah. So if they want to do it, let them do it, right? But of course, it requires landlord's permission, right? So that everyone's happy. How it is to be done, what are the renovations you're talking about, and such. How it's to be managed, arranged. But do take note, right? This is from my experience. If let's say you are a tenant, if you are a landlord and your tenant wants to renovate the property, the thing that you have to make sure is what sort of renovation they are doing. Is it a big renovation, or it's just a small renovation? Well, why I say this is because sometimes renovations require government consent. They require government approval, right? There is such a thing as illegal renovation. For example, maybe you want to add another floor to a building, or you want to break down a wall of a building. That's considered quite a big kind of renovation. It changes the layout of the property as well. So it's definitely something you have to work with your landlord, and your landlord will have to approve all these things as well. Get the necessary government approval, and it's going to take a long time and a lot of money as well. It's just a small renovation. Previously to renovate the whole house, yeah. If your tenant does that without your permission, then that's a big problem. All right, that's a big problem for you, especially as a landlord. As a tenant, the most is they can't live there anymore, or the tenant might be in trouble with some sort of with the government as well, because they did something illegally. In any case, yeah, renovation stuff very common in Malaysia, and that's why I have to tell people when it's a question that often comes up by my clients when they are tenants, when they always ask, I want to do renovation work. Is that possible? I will tell them, yes, it's possible, but you have to work with the landlord, right? You have to communicate with the landlord quite closely on this matter, because If it's a big renovation, or even if it's just a normal renovation, it has to get approval by the landlord themselves. If you're just like changing the fan, or changing the facilities provided, like the air conditioner or anything like that, maybe you just need to get approval from landlord. But if it's like breaking walls, changing the wirings inside the walls, so that it would change the layout of the property itself, yeah, something has to be done cooperatively with the landlord. Anyhow, moving on, comply with law and rules of a management corporation. So again, this one, it depends on what kind of property you have. If the property is like an apartment, a condominium, or a high-rise building, there will be a body, a legal entity. Most likely, they call it management corporation. It's basically the company or the committee that is managing the entire building, right? So they have their laws, they have their rules in how you can act inside the building. So all things have to be considered as well. The tenant has to comply with as well, right? As someone that occupies the building, all these rules are applicable to them as well. Rules and laws. And insurance. This one is, I would say, just in case. It's not that important, but it's a just in case thing where certain landlords are very peculiar about. Insurance here means more towards over here, public liability in respect for any injuries caused to any visitor or invitee or person lawfully present. So this is not about insurance for the building. Insurance for the building is paid by the landlord. There's more of a insurance for things that happened that damages people or people's properties and such. For example, maybe some sort of explosion happened because of the tenant, right? Either because an accident happened because of the tenant, something that is caused by the tenant, right? Nothing related to the landlord. It's the responsibility of the tenant, and the tenant should have some sort of insurance. But it is more of a recommendation or suggestion for the tenant to do. If they don't have it, either way, at the end of this clause, we also mention that no claims shall be made against the landlord, and landlord shall not be liable for or responsible for the tenant for any loss, claims, accident, or damage suffered by the tenant or in respect of the demised premises. Yeah, so this one is more for the tenants, but also optional. If you don't like this, it can be worded in a different way, but landlord might want this to stay, right? Because they don't want to be responsible for actions of you, right? Even it's like, you can safe to assume people have, some people have like told me, or I have argued with me, right? That this is not necessary. I can tell you that, why is it? We can always try to, all these terms and conditions, where it's being argued between clients or between lawyers, we can always argue why and why not. Some people could say this is not necessary. Some people could say this is necessary. But at the end of the day, we just want to compromise on things. So it's entirely, at the end, depends on the clients, whether they think this is important for them or not, right? If the landlord thinks this is not necessary, they can risk it in terms of, like, say, hope that the tenant doesn't come and say it's the landlord's fault for the things that had happened, the losses they had, that losses, injuries, or whatever that happened to the tenant. fine, we don't put that in. But if we are if one of the parties insists on having these terms and conditions to be put in, then we have to compromise. We have to compromise to, which is for a compromise to a sentence that is acceptable for both parties. And we have acts affecting insurance risks. The tenant shall not do or permit or suffer to do anything whereby any insurance of the demised premises against damage of fire may be rendered void or voidable, or whereby the premium for any such insurance may be liable to be increased, and shall make good all damages suffered by the landlord, and shall, as a result of any breach thereof, on demand in resulting from the landlord, pay to the landowner any such increased premium and all expenses incurred by the landlord in or about any renewal of such policy or policies rendered necessary by a breach or non-observance of the covenant with 7 days of receipt of a notice of demand by the landlord to pay the above sums. Yes, it's a one sentence, right? It's a one entire sentence. But I can now explain to you that this is basically telling the tenant, or telling the tenant their obligation is to not do anything to destroy the property, right? Don't cause a fire, don't do anything that would affect the building's insurance. Because if, let's say, it's found out that they are the person who caused the damage or anything like that, yes, maybe the insurance will cover the damage, but of course, it means that there will be increased costs for the landlord, right? Increased premium or something like that, or because if they did something, they might lose the insurance, right? And it's found out it's the tenant's fault to doing all this. Yeah, it's reasonable to say, yeah, the tenant should be liable to pay for these things. Yeah. Are you getting scared, Isaac? Are you getting scared, Isaac? You have all these terms you have never really considered. If it happens, it happens. Right, we have termination, right? Finally, termination. So how do we end? How does a tenancy end? Or at least what happens? What is the tenant's obligation when there's termination? To permit inspection prior to the termination of the tenancy. So basically, over here, this clause is just tells you, if the tenancy is ending, the tenant should be allowing the landlord to inspect the property, right? For whatever reason, specifically for future tenants or purchasers or anything like that, or for them to check the property. And over here, it's termination of the agreement. So when would when an agreement ends, right? When the tenancy ends, what happens? So these are all the things that should happen, which I would say this is like very important for people to know, to specify what are the things that it should take, right, happen, and not just, when you want to leave, then you just talk about it, how to do it. Because if there's a lot of problems when the times come when you want to leave. Like say things you are expecting the other party to do, but they are not doing. Yeah, it happens a lot. It happens very often. And because if you don't have a terms for it, you don't have a way to settle the matter. Right, so first of all, peacefully yield or cause to be yield up the demised premises. So this just means, anything that belongs to the landlord, don't take it away, right? You don't have any rights to take it away. And also, you have to leave them there, and also in working condition, right? Church belonging to landlord in good and substantial repair as well, in accordance with covenants of tenancy agreement. Yeah, so don't destroy the aircon, don't steal the fan, or don't destroy the shower machine, or don't like a laundry machine or whatever. Don't steal things, all right? They don't belong to you when you leave. Don't steal the cupboard. Don't steal the mirror. Don't steal the chair. Or let me take the plasma TV real quick. Yeah. You joke about it, but it happens, all right? It happens. Give up all the locks, keys, and of the demised premises to the landlord. Yeah, this is pretty simple things you have to do. Remove all goods and equipment brought into the demised premises by the tenant. Yeah, so remove anything that belongs to you as a tenant, right? Don't leave your body pillow of me over in your property, okay? I said don't leave things like that because you know the the landlord will just throw it away or might use them themselves. I don't know. You know, it's not good. All right, it's not good. They might sell them as well. You know, might they might sell them, sell their body pillow. Remove all signs erected by the tenants. You know, if it's a commercial property, remove all these things like your logos, your brand, or you know, signage. Yeah, and yeah. In general, just you know, turn it back to the way it was before you came into before you occupied the property. And of course, this is contingency. This is very important. The last thing that we have here is, what if the tenant doesn't want to go away? Whether the tenant doesn't leave. So we have this covered as well, right? It's good, right? It means that at least good for the landlord. Okay, good for the landlord to specify what the landlord can do, because sometimes if you don't specify these things, it's actually illegal or actually an actual criminal offense to do certain things. In the event that the tenant remains on the said demised premises after the notification to vacate, and the tenant hereby fails at neglect or refuses to yield up and vacate the demised premises within 14 days from the date of the notice is sent to the tenant, the landlord shall then be at liberty to enter the said premises without having the consent of doing so, and the landlord shall do whatever is necessary to restore the said premises to original state and or condition, fair wear and tear accepted. So yeah, this allows the landlord to have the legal right to go into the property, do whatever is necessary, right? I'll try to explain any situation that involves in this to my best of my knowledge, all right? But we'll read through the other paragraph. The tenant occupying the demised premises or any part thereof shall be entitled to remove all fixtures and fittings belonging to it, provided that all damage shall be made good by the tenant and or the third party, as the case may be, after the removal of such fixtures and fitting. Upon handing over the keys, the landlord and tenant's representative shall jointly inspect the demised premises, and the landlord shall be entitled to deduct from the deposit such sums as may be necessary to repair or make good any damages or breaches by the tenant over the such third party. The landlord shall not be obliged to refund the deposit until the damage and or breach has been made good or such repairs have been carried out or paid. So this paragraph and this paragraph is different. So the first one, right? Things you can't. I don't have contract, so I can stay forever. You wish I did. You wish you could do that. So basically, yes, you can enter the property as landlord, right? But the landlord can't. What the landlord can't do, okay, is lock someone in the property, right? Don't think because you know the person shouldn't be in the property, it means that you can lock the person inside. It's a criminal offense. It's considered false imprisonment. All right, you might kill the person as well if you lock them inside. So that's not something you can do. But if let's say you can go inside, If there's no one inside, you can lock the property, okay, from from the tenant from getting inside the property. That you can do. All right. Other things you can't do, like you may or may not be able to do, depending on the agreement, is the landlord. I'm specifically talking about. The landlord may cut off water, right? The landlord may cut off water. The landlord may cut off electricity. But this is not necessarily something us lawyers would even suggest you to do, right? Even if we put it in the agreement itself, because it's a matter of person's danger, person's risks of health and harm. If you do this sort of things, even if you have the legal right to do, right? Even if you have a legal right to cut off water supply or electricity supply, to try and force the person out, evict the person out of the property, chances are it might, you have to consider whether it's a family, whether they have children, whether they have babies or not, anything like that that might cause a problem, elderly, anything like that. You don't want people to die. You don't want people to die. You don't want people to be harmed, injured, because you want people to be evicted or something like that. But yeah, there's something to take into account. All right, Isaac, you're living alone. And if let's say you want to stay there forever, your landlord might do things like that to force you out of the property. Anyhow, failure to vacate the termination. Yeah, so this is something which I just said. Fail. All right, so if you fail to do these things, what can the landlord do? Landlord can, the tenant shall pay to the landlord as agreed liquidated damages equivalent to 2 times the rent or 2 times the current market rental for each day's delay. Yeah, so however long you stayed there, you will have to be, you have to pay. If you're the tenant, you don't want to leave, right, Isaac? Assuming you don't want to leave, you have to pay the rental, right? You have to pay a rental. It's not like you can stay there for free, right? We assume, especially if you don't have a if you don't have a agreement, it's I would say based on case laws, right? It's safe to assume that you have to pay. You are considered a month-to-month basis kind of tenant. You're not a forever tenant, right? Now, for however long you stay there, the accumulated rental that you have to pay is still there. It's still getting counted on a month-to-month basis. Whichever is higher without prejudice to the landlord's right to evict the tenant to take proceedings or actions to enforce the other rights of the landlord at law or contained in this agreement, including but not limited to remedies specified in Section 8. So we'll look at what Section 8 talks about. It's basically the rights of right of the landlord. But yeah, we'll look into that further. But yeah, it's quite a lot. The landlord has a lot of things they can do. Then payment of charges. Oh, so yeah, this one is also very important. Okay. Although failure to vacate is very important as well. Termination agreement is important. Payment of charges is very important as well. This basically tells you, I don't have to read the entire thing, but I can explain to you that this way it determines whether the tenant pays for electricity, water, sewage, telephone, Wi-Fi, or any other things. Maybe there's like a maintenance bill, or even tax, right? Even tax. It can be discussed. These things are not fixed in stone, like saying who must pay what and who don't need to pay what. although there's like standard practice or like there's some sort of rationale to it, but there's no law to say that as a tenant you must pay this, or as a landlord you must pay this. Right? So yeah, this is something that has to be said, has to be covered, has to be specified, right? But of course, over here, right, also mentions like what happens if the tenant doesn't pay electricity bill, what doesn't pay for the water bill or whatever. Then you can say, you know, landlord, over here, at least over here, right, it gives the landlord additional right to suspend or terminate the utilities being supplied to demised premises, including without limitation, the electricity, water, and telephone supply, and the tenant hereby authorizes the landlord to carry out suspension or termination of the utilities. So this is something to further extrapolate, right? The landlord doesn't themselves cut off the water supply, or they themselves cut off the electricity. Even though they do have the right, but they do have to work with the government, because these supplies is not controlled by, or is not under fully the right of the landlord or the legal owner, because this is technically supplied by the government officials or supplied by the companies, right? The water, the electricity. So if they are not paying the electricity bill or water bill directly with the companies, then, you know, you can communicate with these companies to see if you can cut off these sort of supplies from the property, right? Because the government well, depends on the country, I guess, but it's a government company, or it's a fully private company that deals with all these supplies, you have to work with them. Yeah, work with them. And so, yeah, Isaac, about the thing that you just asked, whether you can rent to another person at higher rent. Well, over here we have, at least in this agreement, it says no assignment of tenancy or subletting. So basically, if you do want to rent to another person, right, you need to get permission. You need to get consent in writing of the landlord to do this. Sometimes people will say, yeah, you can do it. Sometimes landlord will say this, sometimes landlord will not say this. Like they will just say, yeah, you can do it. But if you don't have an agreement, you can sway in both ways, whether you can do it or can't do it. And we have indemnity clause. Yes, even here, or I would say any contract, all right, would have indemnity clause. Whether this indemnity clause can be enforced or not, it's another thing. But it's always safe to put this in so that you can limit some liability. Hopefully, instead of like trying to argue in court to say, no, this is their responsibility, or this is their this loss or damage or injury isn't caused by this party, so it shouldn't be up to this party to cover the cost or to become compensated. Whatever the reason is, that's why indemnity clauses are always going to be a thing in contracts or agreements. If you don't like it, it's hard not to put in these things. It's hard to justify shouldn't be put in these things, because if people aren't putting this clause and aren't putting indemnity clauses, are we trying to tell people, you know, trust me, bro? Basically, it's at the end of the day, if we don't have these sort of clauses, if we don't have cover specific situations, are you telling people to, you know, do people still say that? Trust me, bro. yeah, it's not good, right? It's not good. It's not good enough to just have based on the words of the either tenant or landlord to just yeah, we won't do anything bad, or we won't sue you, or we won't like sue you for damages or anything like that. Yeah, just trust me, bro. So no, yeah, it's a lot of things that's like we might, if let's say the landlord or the tenant is like best of bros, long, or even like wife or husband, I don't know, or maybe they are brothers or sisters or parents or children, or very, very close relationship. They trust each other their lives. And would that mean anything when it comes to this sort of stuff? Right? The person might have like saved your life multiple times, but there's always a risk that someday when you do business together, or do some agree to some sort of agreement, a contract, something might happen. All right, people might change. They might have a bonk in their head and they became a different different person, and they are evil now or something. And all the past relationship, the past memories, the things that you've done together all mean nothing, and you will suffer for that, right? I'm just talking about a very extreme situation, but you know what I mean, all right? Jake watched too much drama. It's not about drama, watching too much drama, all right? It's real life things happening, especially from what I've heard, from heard in cases such as wheels, all right? You think this happens in dramas only, where family, a parent or like grandparents died in a family, and they leave inheritance to their next generation, to their surviving family. Or you think, all of them are family, they will just resolve this issue peacefully. But no, things that happen in drama actually happens in real life. Families fighting for assets, fighting for properties, fighting to say the will was wrong, it was not, it was it's illegal, it's void, or all these things. I've heard, right, from like lawyers that are specialized in this sort of field of law. Families, own brothers and sisters fighting for a piece of assets, inheritance. Has that only happened in Reddit drama? No way. It happens in real life, right? No matter what the relationship of anyone is, it's always good to have this backup, right? Always good to have this as a backup. I would say, if anything, agreement is considered like a backup in case the worst case scenario happens. Anyhow, I don't want to really go into this in depth. It's basically, you can't sue me for this, you can't claim for this, you can't. If I get sued, you have to bear all these costs and such. If people don't like this term, you can always like be very, very strict about it, compromise, negotiate, amend it, however you want to do it. And we have change of utility accounts. This is depend on countries, I would say. Maybe it's not a thing, it's a thing, but sometimes tenants may or may not want to change the utility bills to their name, create account for their property themselves, so that they can directly pay for these utility bills, right? You don't have the landlord to pay for these things. So over here, this is essentially telling the tenant have to create accounts for like the electricity company or the water company or the sewage company, all that stuff. Then we have the landlord, right? Landlord's obligations. The landlord promises to the tenant on what they should be doing and not doing. So first off, quiet enjoyment without interruption. So the landlord, even though that the property is theirs, legally theirs, it doesn't mean they can anytime barge into the property as they like, right? So this is something that people might know, might not know, is that they can come in and inspect the property and such, but it doesn't mean they can come in and live in the property or like just treat it as their home or anything. There have been cases on this where landlords just treat it as, you're like a housemate or something. A tenant is a housemate and they can come in and go wherever they like. But no, you can the landlord themselves could be considered trespassers, all right, in certain situations. What's up, homies? I own this house. Right? They could still be considered like considered committing criminal offenses if they barge in willy-nilly into the house, into the property. Then payment of credit rent and other rates. So over here, at least in this contract, it is the landlord's responsibility to pay all the taxes, right? In Malaysia, we call it credit rent. Credit rent is like the land tax, and assessment is basically assessment tax. For your information, land tax is basically everyone has to pay this. At least for all legal owners. And why do we pay this? Is, government needs money. The property, the land itself, right? Even though you own the properties, the land itself is kind of still by law owned by the government, owned by the country, and that's why they have the right to charge you this land tax. Doesn't the landlord need to pay that? Not necessary. Not necessary. There's no. You mean? Even though it's there, yeah. Legally speaking, the landlord is the one who should be paying for these taxes. But the contract could be worded in a way to say they pay the tax, but they are, how do you say? They include this cost within the rent, or they include this as part of the rent or whatever. However they want to word it, it might just tell you, this is additional payment or something like that. They need you to pay this, right? They can word it in a way that to divert the cost towards the tenant. That's why this is important, right? It's important for you to know. If you have a landlord that wants you to pay this, it's not fair, you could say. Yeah, it's definitely not fair. The tenant shouldn't be paying this money because it's the landlord who should be paying it. Logically speaking, rationally speaking, right? Because they own the property. This is nothing about nothing concerned with the tenant. Why does the tenant need to pay the land tax? Why does the tenant need to pay the assessment tax? Oh yeah, so about the assessment tax, it's more another thing where the government has to do in terms of all properties is by right, legally speaking, right? One of the duties of the land office, not the land office, this is more towards the state town council of sorts. Yeah, town municipal, however you want to call it, the government that handles the day-to-day affairs of a city, a town, a village, or whatever you want to call it. They will go to properties. They are the ones who give out approvals for renovation work. So they also keep a record of all these layout plans of a property because of this renovation and such. So they also assess they also assess the values of the properties. So that's why they call it assessment tax. The government will from time to time go, at least I would say half a year, check on your property. Although they do this, they don't physically go and check your property. They do only do this based on the records they have as the government, like all the properties within the area in general, how much they are, how much the price has been going up, people are selling it, what's the market value and such. And if there are recent renovations worked on the property, they probably have to include that into their assessment. That's why if, let's say, your property, the assessment tax depends on how valuable your property is. If your property is like 100,000, is valued at 100,000, then their tax will be based on 100,000. If your property is based on a value of 1 million, then that tax will be based on 1 million. So yeah, this tax is really dependent on what your property's value. But this is really more of a how do you say, fun fact only. It's tenant doesn't, as a tenant, you don't really have to be concerned with this. But a landlord, yeah, you have to be concerned with this. But also might be very specific knowledge in terms of country. Other countries might not have this, might have this. Right, next is maintain the main structure. So don't need to explain this. Everything about the property, pipes, wires, walls, floors, ceilings, roofs, all that is the landlord's problem. The landlord has to maintain all those things. Unless, you know, we always provide this. Unless the tenant cause all the problems, all the damages, then yeah, it'll be the tenants to repair all these things, or at least cover the costs to effect repair. So yeah, again, another clause to say that the landlord has to go and repair stuff, when to repair stuff, how to repair, how the tenant should notify the landlord to do all these things, blah blah blah. Yeah, all this is very important to lay out, right? Entitlement to a fixed sidewalk. If this property is a commercial property, then you have to, like, you know, give a very specific indication of how this is to be done, right? Then we have no legal restriction to enter this agreement. This is more of a general thing. Hereby confirms there are no legal restrictions within landlord's knowledge. Man, tongue-tied over there. Which would in any way invalidate or otherwise affect the validity of this agreement, or that would restrict the landlord from entering into this agreement hereby created. This is pretty simple thing. It's landlord promises that, you know, landlord didn't rent this to another person, or it can, within all his knowledge, within all his understanding, that there's no problem with, you know, entering into this agreement without any restriction, without any problems. To a fixed fence. So this is more towards land properties. To a fixed fences before the expiry. This is very optional. This is a very optional thing. Sometimes if a property doesn't have a fence or have a broken fence, something that is missing, it could be something else, not just fences. So maybe a window that's broken, but the landlord has promised they will fix this, right? Or they will build this thing, or build a partition for rooms or something. Yeah, so they would have this sort of a term over here. Well, for at least for this one, it's about giving the landlord 6 months time to put up fences for the property. Then we have event of default. So what happens either the tenant defaults or the landlord. Well, most likely it's not the landlord, it's just the tenant. In the event of the following occur, the rent reserve or any part thereof or any payment due and payable to the landlord under the terms hereof shall be unpaid for 14 days after the due date. Alright, so that's considered a default. That's considered a breach if you don't pay for money after 14 days when it's due. The tenant fails to observe or perform or commits a breach of any terms or covenants here in this agreement, and the same is not remedied within a period of 30 days from the date of receipt of written notice of such breach by the landlord. So you breach something in the agreement, landlord finds out, landlord gives you notice to fix it, to repair it, to remedy it within 30 days. If you didn't fix it within 30 days, it's a breach. Tenant shall become bankrupt, wound up, whether compulsorily or voluntarily, or enter into any arrangement or composition with its creditors, or suffer any distress or execution to be levied on its goods. Then, in any of the said cases, then landlord shall be at liberty to serve a notice on the tenant to remedy the breach, as it is hereby agreed and deemed that the period stipulated in the aforementioned notice shall be 7 days, where the breach has not been remedied within stipulated time. The landlord shall be at liberty to take any time thereafter any one or more of the following remedies without being responsible for or liable for any loss, damage, or expense caused to the tenant as a consequence of such action. Yeah, so then this is more like if they bankrupt, wound up, all this stuff, it happens, it is considered breach, because if any of this happens, then the following things will happen. This is the consequence that will happen. Consequence will be agreement will be terminated, of course, and landlord will have to take possession of the demised premises with the written law for the time being in force. So yeah, however legally possible that a landlord can evict a tenant, they will do it. They will forfeit the deposit. So deposit here includes security and utility, okay? Take note of that. Sometimes they will specify just security deposit, sometimes they will specify depend on situation and how it is forfeited. Because most of the time it's a standard to put in deposit. Everything will be forfeited if you breach the agreement. Claim for the rent and all other sums provided herein for the remaining period of the tenancy hereby created. So this is also very important, you know. If let's say the tenancy, if you breach the tenancy, all right, but the tenancy has a period for, let's say, make it simple, 1 year, right? But you only rent a place for 6 months, and down the line you breach something in the contract, you breach something in the agreement. This cost would mean that you have to pay the remaining rental period that you are not able to occupy, right? Even if you are not, even the reason for the breach is that you didn't pay for the rent in the first place. Landlord is legally allowed to claim to demand all the money, all the remaining months, right, that you have promised to stay. So it could be a very big amount, a huge amount, depending on how much the person you're renting per month, right? This is something I would say, if you find this clause in the agreement, be very careful. Consider all things, all right? As a tenant, all right? At least this, because this is a very clear-cut term that is in favor of the landlord. So a tenant, there's nothing good about for this tenant if they breach a contract, all right? If they breach the agreement, there's nothing good. You have to pay a big amount of money. And sometimes the landlord would chase for this money, depending on how much it is. And even worse, if let's say the tenancy period is not just 1 year, it could be 2 years or 3 years. All right, you have to take note of that very carefully. Sometimes a landlord doesn't put this in, and yeah, it'll be good for you, right? But it won't be good for the landlord. So this is something that is negotiable, right? There are some terms and conditions in, as I said, some terms and conditions in the agreement is negotiable. Some of them are not really negotiable. It has to be there for the sake of everyone, for the sake of a fair transaction happening, for the sake of a peace and mind for everyone. But some things like this over here, right, can be said, can be argued whether it should be in this one or not. Then over here, suspend or terminate utilities being supplied to demised premises, including without limitation electricity and water supply. Again, I explained about this thing. Okay, so we'll just move on. To sue and take any actions landlord deems fit to recover all monies due and owing to landlord. So this is more or less, telling you, yeah, if you don't do anything, we can still, if you don't do anything to comply with the agreement, we can we can take actions in court. The landlord can take actions in court to get all this done. Either you don't want to leave the property, or it's because you haven't paid rent, or other things involved. Right, then we have additional rights and remedy of the landlord. Again, this is reiterating how everything should be done in regards to the not paying, the tenant not paying money, the tenant not paying rent. Hippity hoppity, your land is now my property. Doesn't work like that, okay? Doesn't work like that. We're not in a fantasy world. But interesting, you reminded me, I think it only happened recently. I just saw a video clip of it where apparently a person owned a property and for a long time, didn't visit the property, and the whole family was living in there. The whole family is living in there, treating it like they own the property. It was quite interesting video to watch. They were like the squatters, like people who are illegally trespassing or living in a place are called squatters. Heard about it from Reddit. Yeah, I saw it from Reddit actually. They quite literally told the owners, you didn't, squatter laws or something like that, squatter principles or whatever, because we've been sitting here, we've been living in this place for some time, so it's ours now. So fun fact, actually, the laws, at least in the British system, used to have something like this. You say it's crazy, right? They actually used to have something like this. You used to have a law that actually allows trespassers, squatters, if they have lived in a place for amount of time, occupying for an amount of time, it automatically becomes their property. But it's been quite some time. I don't remember the specifics, but it's possible. In the old days, all right, maybe hundreds of years ago, it could, people could, squat and then own the property. But nowadays, no, they removed the law totally. If the property is abandoned like 10 years, so yeah, so there used to be a law like that where you could do that, but now no, you can't do that. You can't say, yeah, I've been here for years, nobody was here, so I could stay here. But I would say even then, like in the past, even if the law is still there, it's very hard to enforce these things. Yeah. There has to be very specific factors to look into for squatters to be able to do that. But anyhow, yeah, tenant also agrees that landlord shall not be known. Oh man, my throat is very itchy. In the past, you get killed instead if you do that. Yeah. Tenant also agrees that landlord shall be under no liability was the suffered by tenant arising from a cessation of the supply. Yeah, this is again talking about the utility supplies. Interest. In addition to and without, yeah, so this one is late payment interest. What does this late payment interest involve? Any amount of money. Any amount of money that is due to the landlord will accumulate interest. Of course, again, this is something that whether you can decide whether you want it in, you don't want it in. A landlord would want it to be in this term, in this agreement. A tenant would not want it to be in this term. Basically, it's like how do I explain this? This is a very common thing in at least in conveyancing, in property, real estate property agreements, where if someone doesn't pay money and a certain time has passed and they still haven't paid, then there will be interest accumulating for it, right? Sometimes it could be the rental, just the rental. Sometimes it could be the cost, some sort of repair, the cost that you have to pay to the landlord and you're not paying the landlord, that would incur interest as well. So yeah, this is something you have to take note as well. If a contract has this term, don't just assume that, oh, I haven't paid the rent for this month's rent and I'll only have to repay this amount of rent, no matter how much time has passed. But yeah, this is to deter people. If let's say they are like really not on time paying for rent, but they do pay rent in eventually, right? But of course, there's landlord wants to have some sort of like compensation for this sort of delays, whether or not you pay earlier, you pay how late you however late you pay for this money, right? Again, negotiable this term. And of course, this is another very important thing, which it's kind of what happened, which we recently talked about, you know, about the extension renewal thing on a different channel. So yeah, this is another very important term to make sure, you know, if you're like, you want to rent a place and you want to have a contract renew automatically as a tenant or a landlord without having the hassle of mutually agreeing on this, like confirming that, you know, it will be renewed every time the tenancy agreement expires. So with this term, right, with this term, at least for maybe for a couple more terms, for a couple more periods of time, it will be automatically renewed. So in a tenancy agreement, you can put things like that. You can put such a terms into it where it will automatically renew the tenancy period. If let's say it was for 1 year, you could put in like 3 terms. It will automatically renew for 3 terms without anyone having to further negotiate, further discuss about these things. Is this a normal contract for renting? So much content to read through. It is, I said, it is. I would say this is already a simplified version. I would say, yeah, a simplified version. There are other types of tenancy agreement that would include a lot more stuff. But I would say this covers most things that people, whenever people like are entering into a tenancy agreement. You're glad your rented room don't have any contract? Well, that's your prerogative, Isaac. That's your right to believe what is good for you. I can tell you, every time anyone that I disagree on that sentiment, and a lot of times problems arise because contracts were not signed, more than contracts were signed, and problem arise from that. So yeah, over here, at least for this one, right? The tenancy period is renewed automatically, and also we will mention if whether the monthly rental is increased at a fixed rate or is increased mutually increased, right? Depending on the market rate or anything like that. But because there's like this sentence, you really have to really look into it. Mutually agreed. If you can't mutually agree on a rent, and of course, there won't be a renewed term. And over here specifically, any request for such extension or renewal shall be made in writing 3 months before the expiry date of this agreement by the tenant to the landlord. This would be in favor of the landlord. That's why I tell people this can be different. This entire thing can be different depending on anyone. There could be a renewal term. There can be a no renewal term. And even if there's a renewal term, it can be worded in all sorts of different ways, right? It could be worded and say that rent will be fixed for all renewals. It could be said that rent is increased at fixed rates, right? Like over down here, this schedule page, it could there could be a part to say, yeah, for this second period, for this first period, rental is for this much, and for second period, the rental will be increased to this much, etc., etc. Okay. And this one, all right, about the request for extension or renewal. This could be worded in any way. It could be worded to say that landlord is the one that has to make the request to renew. Then it will be renewed. Or it can be both parties have to agree that not both parties. It could be the other way around, wherein you have to give notice to tell the other party that you don't want to renew the tenancy agreement, renew the tenancy period. Right? That could be another way to doing things. So if there are no notice given to either party, then it's assumed that the term will be renewed automatically. Either the landlord or the tenant may give 3 months written notice to terminate the extended agreement. Yeah, so this is also where you can also put in to say you don't want to renew it anymore. You don't just want to end it. You can also make that choice, right? You make that choice. That's why I tell people notice of termination and notice of extension or renewal or request of renewal of tenancy is different. Very different things. They give effect to different, they are very, the consequence of it, the effect of each notice is different. Right. And we have miscellaneous. I don't think we really need to talk about this in depth because this is like, again, if you have seen my terms of service explanations. These are all standard stuff. But of course, you know, for tenancy agreement might be different, slightly different, but also very easy to explain. Schedule as part of this agreement. So you've seen the schedule already, right? The schedule is this part, schedule 1, with all the details, names, the address, the property, the rental, how much the rental is, the deposit, how much deposit is, the tenancy period, all of it is over here. So this is just to solidify that that schedule part is part of the agreement. It's not something extra or anything that you don't have to like look at. It forms part of the entire agreement as well. And we have cost, right? We need to determine when we especially, all right, if this agreement is drafted by a lawyer, we have to determine what any payment in regards to this, right? And also agreements to make it more valid, to be more enforceable in court, right? Just in case, or anything happens, there's a breach of contract or anything like that, you have to pay stamp duty. You have to pay some sort of a for most cases just for stamp duty, but also maybe registration fees. Basically, a lot of legal documents, if you want to have it some sort of credibility, enforceability in court or anywhere, you have to let the government, quote unquote, check them. All right, you have to let the government check these documents for their validity. But for tenancy agreement, the government most likely just check how much, what's the tenancy period, to determine how much stamp duty they have to you have to pay. Stamp duty is basically a tax on legal documents. So for tenancy, there's a rate, all right, a rate for to determine how much this is to be paid. It's based on the tenancy period and also what's the monthly rental. The higher it is, of course, the more expensive it is for this stamp duty. But we know normally it doesn't cost a lot. And of course, in this agreement, it is for the tenant to pay for this one. I can tell you this. Sometimes, when you rent from an agency, all right, not like IZ, this a sales agent doesn't have give him a booking form to sign. Maybe, I don't know. IZ, you just told me you have signed nothing, so I'm assuming you have signed nothing. Meaning to say, let's just assume there's a booking form or there's a contract. Most of the time, sales agent or tenancy agents would directly with the landlord. Okay, so yeah, no contract at all. So I can't talk about this with Isaac. Isaac will not relate to this, but yeah. Sometimes agents will help you do stamp duty. Will pay for it, even. Sometimes they don't. Right? If you don't have a lawyer to help you with doing this, you can do it yourself, right? You can do it yourself. But of course, you have to do with all copies of the agreement. If you have signed 3 copies of the agreement, all agreements have to be stamped. They need to be stamped. Oh my goodness. It's 5:16. Stop. Don't start sawing now, okay? Stop grinding stuff. Bad renovation work suddenly starts again. But yeah, this is very important to note. Cost. Find out who pays what. Whether the landlord pays anything in regards to the creation, to the drafting of these documents. All right. Also, if let's say again, this is very common for anyone who approaches a lawyer to do all these agreements. Make sure, if you are very concerned with the terms and conditions and As a tenant, normally as a tenant, you won't have a lawyer representing you. Especially, oh boy, it's 5:15 p.m. Need to start drilling. Yes. I don't know why they haven't do any drilling earlier, but well, I'm almost finished with this live seminar anyways. But yeah, don't assume if there's a lawyer, it means that they are representing you or they are representing both parties. A lawyer cannot represent both parties at any given time, right? Whether it's drafting for you or they are negotiating the agreement for you or advising you on anything. And when there are two parties involved, a lawyer can never represent both parties. They can help negotiate things for both parties, but at the end of the day, officially or legally speaking, they are representing one party only. Right? How do you determine this? Not by who pays who, although there's a good indication, but sometimes there is a agreement of sorts like this party would be paying the costs, but officially or legally speaking, it's been the other party. It's been written to say this law firm is representing the other party that isn't paying for legal fees and such. It could be that possibility, right? Not necessary. If the person pays for the lawyer, means that they are the ones that are being represented, right? And if you're concerned, if you are worried about this, better to get your own lawyer, right? Get your own lawyer, find your own lawyer to look at all these documents to negotiate this agreement. If you can afford it, of course. All right. Even if you can't afford it, it's that's why we're talking about this, all right? That's why we're talking about this. At least to some certain extent, you are able to read through a tenancy agreement to find out what is good for you, what's not bad for you. But again, oh my goodness. Again, I'm not giving any legal advice. This is not to be construed professional advice. Right? Please consult. But if you do find anyone, if you do find yourself in such a situation, you have to find a lawyer or you don't have a lawyer or anything like that. Make your own decision, all right? Decide on it for your discretion, right? Don't rely on my on this live seminar or anything that that people aren't professionally acting on behalf of you. Okay, this is a disclaimer. I should have said this earlier. Anyways, yeah. So moving on, right? Moving on. Time. This is standard as well. Whenever time is mentioned, it shall be essence of this agreement. This is more of a really standard thing, because in the past there have been cases, all right, at least from what I've studied, where if you don't mention time is essence, whenever, even if you put like things has to be done, it has to be paid within this amount of time, people can argue, you just put in here that not necessarily it's important, right? People could argue that in the past, at least, but I would say in this current modern time, in this current modern legal system, it is always safe to assume that the court would or anyone would assume time is of essence. But then don't leave for any sort of doubt in any party, in anyone. That's why we put in time is important whenever it's mentioned. And of course, this is notice. This is just telling you how it should, in terms of communicating with either party, from landlord to the tenant or tenant to the landlord. This is how things should be communicated, how things should be sent, whether it should be sent through mail, registered post, fax, email even, or messaging. Yeah, anything that requires sort of a notice, official notice, that is to be done because of what this agreement has mentioned, is found here, right? And knowledge and acquiescence. Knowledge or acquiescence by either party hereto or any breach of the conditions, covenants herein contained shall not operate as or be deemed to be a waiver of such conditions or covenants or any of them, and notwithstanding such knowledge or acquiescence, each party hereto shall be entitled to exercise their respective rights under this agreement and to require strict performance by the other party of the terms and conditions therein. So this is just simply, yeah, it's very normal, very standard to say that even if someone has breached a contract or someone has breached a terms and conditions, and the other party hasn't done anything to tell them to rectify it or remedy it, it doesn't mean they have accepted or is okay with the breach, right? Silence does not mean their acceptance, or silence doesn't mean they are okay with it. And successors found. This agreement shall be binding upon heirs, personal representatives, assigns, and successors in titles of the parties. So this is again very standard term. If let's say you passed away for some reason, right? It doesn't mean as a tenant you don't need to pay anything anymore. As a child of the tenant, or as a heir to the tenant, someone that is a representative of the tenant, maybe it's a company, right, and it's merging with another company, doesn't mean this agreement is void or anything. You still are bound to the terms and conditions in it. Entire agreement. This entire agreement constitutes the whole agreement between the parties hereto, and is expressly declared that no variations shall be effective unless agreed to the parties hereto in writing. So then there's this covenants. Yeah, both of this just talks about, you know, everything that's agreed in here means the entire thing. It means the entire tenancy. There won't be anything else you should be referring to. There's no changes, there's no amendments, there's no extra legal documents for you to look at that is related to this tenancy, because whatever terms and conditions you need to comply with, this is the entire thing. And we have invalidity of provisions. Again, you see this very often. Everywhere, if some part of the agreement is not enforceable because of laws and such, you know, doesn't make it the entire agreement is void or voidable. It still can be enforced for the parts that are still enforceable. And goods and services tax. So this is like a depends on country, depends on the type of depends if it's a company, the tenant is a company or not. Renting might involve landlord is a company, or renting a property might be a business. Renting a property might be a business, so there might be considered tax involved in it, right? If the landlord is a company and they own a lot of properties, and all they do with the properties is rent out to people, rent out to other companies. Yeah, if possibly the rental money could be considered, what is it called? Income tax? Yes, we can consider income tax for companies, and might also be, yeah, they have to pay for it. It might be inclusive. Rental might be inclusive of this sort of tax as well. All this is this agreement is covers a lot of different things, and that's it. Right now over here is where the signing page is. So landlord will sign here, Jake Light will sign here, and tenant Jake Knight will sign here. So once you sign this document and having a witness to witness your signature, it'll be it. You have agreed all the terms and conditions in here. right? So again, not again, anyone that's signing any legal document, once you do this, once you put your signature in it, there's no other, can't complain any further. It's assumed that you have agreed to all the terms and conditions. That is the power of signatures, as in the legal implications of signatures. Because we have all this Schedule 1 again, all the legal terms over here, all the specific technical terms, the details about the tenancy is situated over here. And of course, if there's a letter guarantee, as I said, if the tenant is a company, maybe the landlord wants a guarantee letter from the directors themselves to promise that they will be paying all the rental or any money due to the landlord, in case, you know, the company itself doesn't pay them, doesn't pay the landlord. So yeah. Oh boy, how wasn't that long, right? It wasn't that long. So I finished the entire thing now. Oh boy. So yeah, if there's anyone have any questions, this will be the best time to ask them. Right, as I will be stretching about, moving about for about maybe 5 minutes. Not too difficult, right? I would say it's not that difficult. It's not very complicated. What a tenancy agreement or agreement that involves a tenant and a landlord. As long as you know these certain like categories of things that you need to be wary about, just look at the titles. I'm very certain most legal documents like this, they have a heading, they have a subject, they have a title for you to look at. Maybe even a list of content page. Nah, but that's not likely. For this kind of like really small documents, they won't really have these sort of things. Not even a sales and purchase agreement. But yeah, hopefully this is helpful. Hopefully this is helpful. And quite literally a lot of how do you say, you see a lot of horror stories from in the internet, especially in the Reddit. Like, people really don't like landlords. It's like it's from what I can tell the community inside Reddit, it's like if someone is a landlord, it's a red flag or something. They assume they will be a bad person, or the minority of landlords is a bad. It's good, but there's nothing. I would say there it shouldn't be such a how do you say prejudice against landlords. Against landlords is an entire different case. Yeah, I mean, we have problems here in Malaysia as well. I've heard horror stories as well, you know, working as a real estate lawyer in the past. Horror stories about landlords, tenants, you know. A lot of times when they come and try to see what they have, what their problems are. At least in Malaysia, okay. I can tell you that if you want consultation from the lawyers in how to deal with a certain situation, that you not necessarily want us to represent you to talk with other people, you just want us to look at the documents and such, we can do this for free. But I would say most law firms can do consultation work for free. They just need you to provide necessary documents, and if you don't need them to do any checking per se, like go to land offices or such, even then sometimes law firms would do it for free, depending on the connections you have with them. Like, have you checked if they are legit legal owners, if they are not trying to scam you or fraud you. They can do all sorts of search. We can do company search, we can do land search, we can do even verify if the person is an actual citizen sometimes. Or if there's like any bankruptcy on that person. That's very common thing that we do, a bankruptcy search, a winding up search, whether the person has any dirt on them. So that's something I think it's good to know, right? At least for Malaysians. I'm not so certain about other countries, whether you can just ask for advice without them charging you for consultation fees. So when I was working as a conveyancing lawyer, because of how we work, we don't ask for money for consultation, because it's like we don't really get we don't profit from that much, right? We will profit better, we'll have a better likelihood of people hiring us to do work if we provide this sort of certain services for free. Like really, when this is I would say this knowledge is very not common at all, where it's very easy for us to look into your case, especially in this sort of like a property kind of case. About drilling, as long as you are able to bring all the legal documents that you have. If let's say you're a tenant, you bring all the necessary details for us to look at, we can help you, we can advise you in certain things. If you bring us, if you're like a property kind of thing, sales and purchase, or like you have a booking form of some sort, you can just let us have a look, and we'll try to tell you is something wrong with it, or what's your rights and such. And you can decide whether you want us to help you, want us to represent you, help you negotiate things, and that will be different, right? Then we will have to charge you for that, because we're doing things on behalf of you. If you're just asking us for what this is, how you should go about on these things, we can give you friendly advice, right? Because it's friendly advice. You can't really say you have relied on this sort of advice and such. But it has been proven helpful for people, right? We've given a lot of this kind of consultation work, and afterwards, maybe it's not the same case that they were having problems with. But in the future, maybe they are buying properties, maybe they are renting out a different property. They'll come to us because they know we know our stuff. They can help us with something. We will do a good job in making sure everything is safe for everyone, is fair for everyone. They can help us fight. We can help them fight anything in terms of like negotiations and making sure the terms and conditions is fair. That's normally how people who are well versed in agreements, well versed in contracts, contractual laws, can help people and make connections and do business. But yeah, let's see. I'm not sure if there's like any questions. Yep, no questions. But I'll give 5 minutes. All right, give my 5 minutes time for people to think if they have anything to talk about. Ooh, there's a lot of interactions happening on my Twitter. Ooh, my tweet about that thing earlier this morning I talked about actually is getting a lot of stuff. Yeah, I guess I can end it with talking about that situation. If the goddamn people can stop renovating behind me. It's... yeah. Yeah, you know, I'll change this, okay? Bum, 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 bum. Hey, Nemo. The one with the stream berating that one viewer for answering his question. Also, hello. Oh, Nemo. Hello, hello. Let me just close this one. I've finished talking about the tenancy agreement. But if you have questions, any questions at all, right? Feel free to ask. This is a pretty broad subject, which I can sufficiently answer anyone because I am a real estate property lawyer. So yeah. Bum, 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 bum. Let me just go and refill my water bottle and I'll come back and talk about that thing. All right? BRB in a bit.